Submit, my lord, here is a matter. It is dismissed for default on the ground of limitation. State went on appeal to the approach the Honorable Supreme Court. So Honorable Supreme Court condoned the delay, remanded the matter to your lordships for hearing.
Yeah.
So, my lord, your lordship, at the first instance, after remand, issued notices to all the opposite parties because my friends, they said, they submitted that files are not with them. So, notice was issued. Thereafter, some have entered appearances.
Yeah.
Lordship may give me some time so that there are some Odia documents, vernacular documents, which requires to be translated.
2 weeks.
2 weeks? Pre-date, yes, it can be.
Set the request of Mr. G. Who wants to file translated copies of Odia documents?
That may be fixed so that matter can be disposed of at the earliest.
Post immediately after filing of translated copies of Odia documents.
Yes, my lord.
Item 2.
Yes.
This rate of appeal is
Make use of the mic.
my lord, in this case, my lord, this writ of appeal is directed against the judgment of the learned single judge while remanding the matter to ascertain the genuineness of the deed of adoption has viewed some suspicion attending the deed. Secondly, my humble submission, while remanding the matter back to the authority for ascertainment of genuineness, the learned single judge as a whole, the writ is dismissed. Therefore, my humble submission for us.
Dismiss this word, allowed. There is a 19, take out the AR 93, bring my notes. Proceedings. My notes there. A beautiful judgment of Karnataka High Court, written by Justice Swami, a great judge of
Yes,
Swami, a great judge of Karnataka High Court.
I stand to read.
He says, the last sentence in the order, dismissed, allowed, rejected, these should not be given significance at all. What is the order should be ascertained from the content and intent emerging from the content of the order.
Spirit of the order. Like that was the second.
Because law is not the slave of language.
But I apprehend that the authority is the collector. Then
Only that one?
no, second point. Second point is the learned single judge has told that the
Post series. Take out order. Post series in my notes.
while
Yes.
while remanding back, the learned single judge viewed that the deed of adoption are surrounded with innumerable suspicion. That, my lord, may outweigh the weightage of the remand. So I may apprehend that that may not be an impartial inquiry.
Right. That you want.
Two, second point, my lord, very important on merit, my lord, that when section 16 of the Act says the deed of
Presumption of
presumption, the court ought not to have ought not to hold that the deed of adoption surrounded with enormous suspicion. These are the points. Third, my lord, then the learned court has directed to collector to make an inquiry. Then, my lord, if the lordship
why that inquiry question arose?
that the learned single judge.
No. Why?
Yes. While passing the order, learned
Which order?
the single judge.
Why that order?
Yes.
No, I am asking you, why you went to the collector at all? Or you went to the single judge?
Yes.
Right? Why you went to single judge?
I went to single judge that the authority
Find out which is money that judge. No, first. Justice.
Let's go.
That be 3 Supreme Court.
that the authority, although approved or recommended my entitlement of family pension,
Oh,
that is,
understood.
they-
Kindly be seen.
so direct that collector may make an
Any
inquiry.
private party is there?
Private party is the department. Seshma.
Only department.
Yes, only department.
Mr. G, when learned single judge is remanding the matter,
Yes.
he can say,
Yes,
doubt arises
Yes.
as to the genuineness of the document.
Diploma.
Beyond that, if he says, the remanding authority to whom it is remanded may be influenced by the views of the judge.
Diploma, that is my.
So, object of remand will not be
Yes.
satisfied. So, we will tone down.
Point should be met there.
That's this intra-court appeal seeks to lay a challenge to a learned single judge's order dated so and so, entered in appellant's WP number so and so, whereby the adoption deed presented in support of claim for compassionate appointment having
No, it
been
is pension. Pension.
Pension. Family pension.
Family pension having been doubted, matter as to the genuineness of the deed is remanded for entrusted for the inquiry at the hands of the collector of the district concerned. First, next one. Learned counsel for the appellant vehemently argues that although it is open to the learned single judge to seek report as to the genuineness of the adoption deed in question, he could not have made much observation which would sway away the remandee in forming an independent opinion after holding an inquiry. First, he also notifies to the court the last line of the order, impugned order, which says that the writ petition is dismissed. First, thus, according to him, there are errors apparent on the face of the record warranting the interference of this court. First, learned AGA Mr. G on request accepting notice for the
No, my lord, it is Tata, private party. I am not.
private party.
Yes.
Company.
Place there.
Having heard learned counsel for the parties and counsel for the appellant and having perused the impugned order, we decline indulgence in the matter, making it clear that whatever observations made by the learned single judge as to the genuineness of the adoption deed should be construed not as taking away the liberty of the remandee to hold an appropriate inquiry and arrive at an independent finding as to the genuineness of the said deed. First time. Secondly, the sages of law have said that the words in the order, like dismissed, inwards, allowed, inwards, rejected, inwards, disposed of, inwards, would not be given much significance in as much as what is to be seen is the intent of the judgment or order as emanating from its text and context. Wide AR 1992 or 93. Right, just the lack of it. So it's first. With the above observations, this appeal is disposed of, treating the impugned order as such, not attaching much significance to the word dismissed.
Dismissed and suspicion. Yeah, paragraph.
That we have already
said.
Next.
Item 3.
My lord, one thing I
All
beg,
contentions of the parties are otherwise kept off.
I beg your lordship's pardon. It's my duty of the record. Your lordship, a couple of months back, put a question as to whether the company, the opposite party, adhered to Orissa pension rule or not. My humble submission, the document they have entered and they have asked me to produce under the Orissa pension rule, and one of the judgment of this Hon'Ble Court where the company has said that we have adopted Orissa pension.
I remember that.
Because it is on record. Therefore, there are orders as for it's my duty. I put my Argo stats to find out that.
Now this will protect you. These observations will protect you. Yes.
Item 3.
Yes.
I have approved.
Can anybody take out the judgment of Division Bench judgment of Karnataka High Court, AR 1992 or 93, where court said dismissed, disposed of should not be given importance. Just do some research. There is such a judgment in my notes. My colleagues are not in a position to lay their hands on hands. Yes.
The defendant has approved this court seeking for interest over the outstanding pensionary duty, pension and the pensionary duty since last more than 19 years, my lord. Though the case has been
Rejected.
pardon,
Single judge rejected the, denied the interest.
No, my lord. Single judge has allowed to the extent.
allowed the entire prayer except the interest.
Yes.
He is not allowed the interest part. It's the result.
Therefore, he is here.
Well,
They are directed to release the pension or pensionary benefits in favor of the petitioner computing his period service up to 10th November 2005 in accordance with law and in terms of OCS pension rules 1992 and release the same within a period of 4 months.
Why not the interest?
Interest was not granted by this.
Take out the Padmanabhan lawyer versus
My lord,
I have given a host of the decisions, my lord, in the court even.
one decision of apex court. We don't weigh how many judgments are
No, my lord.
there. We see one judgment.
Exactly.
Yes.
but my lord, interest shall be given in the case of where the laches lies with the department.
Correct.
But here is a case, my lord, what the judgment says, my lord. The on verification of record, paragraph 9 of the judgment enclosing.
Yes.
It is seen from annexure 4 that the office of the principal accountant general in letter number so and so has returned
Yes.
judgment.
Judgment is page 72, my lord.
Page 72.
Page 72, para 9. My lord,
My lord,
let me place it from para 7, my lord. Let him place it, start
Para
it from
7.
para 7. Para 7 is the issue framed.
Para 7. In view of the rival contentions, the question falls to decide is whether the petitioner has submitted the VRS application on 10th November 2005 or he remained unauthorized absent from the service thereafter. The Director Health Services and CDMO, Sambalpur, have stated in their counter affidavits that the petitioner remained unauthorizedly absent from 11th November 2005 without the knowledge of the authority. And for the first time in the year 2015, he approached the authority for grant of pension in his favor, claiming to have submitted VRS application on 10th November 2005. It is also stated that the VRS application as per Annexure 3 dated 10th November 2005 has not seen the light of the day and has never been submitted to the authorities concerned at any point of time. It is further admitted in the counter affidavit that till date, no disciplinary action has been initiated against the petitioner for his unauthorized absence from service with effect from 11th November 2005.
Correct. Where is the fault on his part?
My lord.
Where is the fault on his part?
My lord, his part is...
He had tendered the application.
No, he has not.
Now,
No, you are saying.
then let us
You
go
are
to next para.
Please keep quiet. The para 7 and 8
Yes.
make it abundantly clear that he had applied for VRS and thereafter he remained unauthorizedly absent accordingly.
Yes, my lord. But
You could have rejected the application.
my lord, it is his contention
Yes.
before the court that he has submitted VRS in the year 2005.
Correct.
But we are saying that he has not submitted a scrap of paper before the department.
Yes.
But that is what our contention.
Yes. Did you hold inquiry?
No,
Being absent.
no, in his absence,
No, then first paragraph of paragraph 9.
my lord. On verification of record, it is seen from Annexure 4 that the Office of the Principal Accountant General in their letter dated 10th November 2012
12.
has
And
returned.
I was 12.
7 years.
Yes.
And he's saying that till 15th was not having.
It returned the pension papers of the petitioner to the medical officer in charge of Hashimal UG so and so with certain queries to comply with. So on the face of Annexure 4, the contentions made by the opposite parties in their counter affidavit that the petitioner has not communicated till the year 2015 and remained unauthorized absent from his service with effect from 11th November 2005 are found to be false. It is for the reason that he has been unauthorizedly absent. He could not have submitted his pension paper to the medical officer, and the same would not have been forwarded to the accountant general.
So learned single judge did not agree that he was unauthorizedly absent.
My lord.
A finding is recorded to that effect after hearing you. And a finding is recorded, right or wrong. You are not in appeal. He is in appeal.
Yes, he is enough.
Then why can't you give the interest? See that Padmanabhan Nair and Chandrasekhara Kambara versus Bangalore University.
Bangalore University.
Yes. Take down. Anything more to be said by you?
No, madam, that was the only.
Kindly take your seat.
But
Take your
I can only bring to your lordship.
Mr. Purohit, you sit down. Yes. If anything else to add, then please.
No, nothing,
Then
madam.
it's all right.
The government has also.
All right.
I am for the AG, accountant. I have no role to play. My presence, please report it.
If you sit down, we will give dictation. Otherwise, you go on sitting or standing, I will also go on sitting mutely. Yes. This intra-court appeal by the pensioner seeks to lay a challenge to a learned single judge's order dated so and so, entered in his restitution number so and so, whereby the relief has been accorded to him in the following words. First, that last question. Next one. Learned counsel for the appellant urges a single point to the effect that when there is a delayed pension, comma, no fault being attributable to his client, comma, the interest ought to have been awarded by the respondents in terms of apex court decision in Padmanabhan Nair versus so and so, so and so. 85 Supreme Court. Is it here 85 Supreme Court?
85.
Fine. First, learned counsel PGA on request appearing for the OPs vehemently opposes resists the intra-court appeal, contending that the appellant was unauthorizedly absent during the period between 11/11/2005 and
10/11/2005.
10/11/2005 and
11th November 2005 to 2015.
2005 and
2015.
what is that? Let's see his case. You sit down, don't worry. What month of 2015?
November.
My lord, I ought to have
We are
retired.
not asking, that is his case. We are asking according to them, what is that?
No, you
In
are not
November
specifying.
2015.
2015 only.
15.
Year was written.
You are simply
Therefore-
saying about year of.
Yeah.
To the month they are giving. Date and month, there is no such culture at the court. 2015, November 2015, and therefore, there lying no fault on the part of the authorities, and the fault being laid at the threshold of the appellant himself, comma, learned single judge is more than justified in denying the interest. First, so contending, he seeks dismissal of the appeal. Next one. Having heard learned counsel for the parties and having perused the appeal papers, this court is inclined to grant a limited indulgence in the matter, in as much as there is a specific finding by the learned single judge at paragraph 7, 8, and 9 to the large effect that there is no finding as to the culpable unauthorized absence of the appellant, and that any culpa is attributable to the authority. First one. If that finding is recorded, then right to interest accrues on the delayed payment of pension void Padmanabhan Nair supra, there being no extraordinary circumstances for denying the same. First one. Next paragraph. In the above circumstances, this appeal is allowed in part. The impugned order of the learned single judge is modified. Learned single judge having been kept intact, a direction to pay the interest at the rate of
Nominal interest.
no nominal. Nominal will not help. At the rate of 12% on the delayed interest payment of the pension, as a superadded direction. First, this interest to be paid within an outer limit of 8 weeks, failing which for each day of delay 100 rupees, a sum of rupees 100 to be paid to the appellant from the pocket of the erring official, paid to the appellant, and this component may be recovered from the erring officials of the department personally. First off, the cost reluctantly made easy. Next.
Item 4. One more thing I will be adding, my lord. They have not given me the provisional pension even, neither any pension after the expiry of 4 months.
Just
I have not
pension you will get.
I have not filed the appeal.
Anyway, full interest you will get. Why provisional pension?
No.
Regular pension.
Final pension.
Even after the order also, they have not paid a
For
single
that, what should be done? Contempt. You know what I will do. We will do.
Because I had.
Next.
Item 4.
It hardly needs to It hardly needs to be stated that the regular pension, along with the interest component, have to be settled and paid to the appellant herein within an outer limit of 3 months instead of that. That's when you put this one. Failing which, the same will carry rupees 100 per day for the first month and rupees 200 for the days next following. Yes.
Item 4.
Yes.
Well, in this case, my lord, though the earlier the matter was settled by the Honorable Divisional Bench of this Honorable Court on the same issue, the respondent number 5 approached this Honorable Court and the Honorable Single Judge, my lord, disposed of the writ petition directing to the collector to reopen the same issue, my lord, raised earlier, my lord.
With that earlier order?
Lords, you can have a glance, my lord. Mr. 1, my lord. Earlier, my lord, the opposite respondent number 5 approached this Honorable Court challenging the selection of the appellant as an Anganwadi worker, my lord. And that was disposed of. Lordship, you kindly have a glance at the order, page 13, my lord.
You are pressing into service the doctrine of res judicata.
No, not res judicata, my lord. But since
Other than res judicata, there is no ground to resist.
my lord.
That's the only ground known to law.
Only ground, my
You
lord.
know it.
But since my
Law knows only the doctrine of res judicata.
my submission, that is the judicata, your lordship, my lord. But since it is already decided by the Honorable
That is called res judicata.
Yes, madam. That is called.
That is what we were told.
Mine.
Class of first year law student.
Mine.
We were told of this.
Mine. Your lords, you can have a glance the order of the Honorable Single Judge earlier, my lord, in the year 98, my lord.
So that
Your lords, you can have a glance, page 13, my lord. Page 13. Last part of the order, operating part, my lord.
which question is
Question, my lord, the Honorable Single Judge, my lord, directed to the opposite party, the collector, my lord, to make selection afresh. Make selection of Anganwadi afresh, my lord.
Yeah.
Lordship, kindly say, have a glance. Just I am placing for Lordship, my lord. Under the provision of scheme and engagement of Anganwadi worker, but middle part, contractual one, but not in permanent one, the same has to be renewed in time and again in the aforesaid scenario without examining the allegation and a counter allegation. I feel the end of the thing. And equity would be better served if the authority is directed to take step for filling of the post afresh
by issuing a
notification, man, in concern to stipulation made in the scheme, my lord. My lord, thereafter what happened? The being aggrieved by that order, my lord, the appellant approached this Honorable Court filing a writ appeal for the Honorable Divisional Bench, my lord. under division of bench without to they modified that order, my lord, stating there in that the fresh selection be made, but made in accordance with the guideline, my lord, relevant at that time, my lord. Accordingly, my lord, collector, my lord, constituted a selection committee, and in the selection, my lord, the applicant was selected. And taking into consideration all the facts and the allegations made by the respondent number 5, my lord. And that order, my lord, under Annex 4, the collector's order. And the appellant is continuing since last 30 years, my lord. Since 98, my lord, that is the selection date of appointment.
What was the date of? It was 2005.
My lord, 2005, order of this division of
1998.
98, that was decided. Again,
Urgent notice. Learned AG requested to accept notice for
I'm for 1 to
1 to 4.
1 to 4,
my
Your
lord.
Lordship. Lordship, if I may permit, that person has already retired. It was the second appointment that was challenged in the year 2013 in another writ petition. That was disposed of. And the appeal is against that order, Your Lordship. The incumbent has already retired, Your Lordship, from service, attending leave.
Let us see what that other formality.
Already retired, my lord. But 2 years service has been extended in the meantime because of good performance by the appellant. Continue.
Respondent number?
This one of 5.
Number 5.
Five.
5.
Written about it in the 4 weeks. But come on, since matter lies in a narrow compass. First. Any interim
But
relief?
interim relief, my lord, is
Classification supported by affidavit in IA number 22 is moved, taking interim protection. Present day appeal. First, the case is made out because of its checkered history, commencing from 1998, commencing from WPC number 12348 of 1998, eventually landing in writ appeal number 32 of 2005. Wherein the fresh selection and appointment was directed. The fresh selection process was directed. First, we are told at the bar that the fifth respondent has also retired from service. Fifth is not retired.
the appellant.
Huh?
Appellant retired from service.
Appellant.
Also told at the bar that the appellant has already retired from service.
And also permitted to continue for further period of 2 years.
And that he has been, he or she.
See, my lord.
Why do you not write Srimati, etc.? Is she your wife?
See, my lord. See, Shiva.
She is permitted to continue for 2 more years. First, if the impugned order is put in action, some prejudice is likely to happen to the appellant is trimmed. First, no prejudice should be caused to anyone if the same is halted, pending, deleted. First, next part, in the other circumstances, application having been favored, the impugned order is stayed in the next day of hearing.
Looking order on Annex 5, my lord.
Annex 5.
Annex 5.
No, we are impugned order itself, we are staying.
Yes, ma'am. All. Obligement.
Item 5.
Urgent copy.
Urgent copy to be acted on.
Obligement.
May I please? In this writ appeal, the present petitioner has filed this appeal against the order dated 28/3/25 passed in IA number 4189.
That is pending. Main matter is pending. WP is still pending.
Yes.
What the order on IA?
23, your lordship may see.
Page 23.
Yes, madam.
Next.
In the entry, has your lordship got it?
Yeah.
In the interim, opposite party number 4 shall not be allowed to participate in the process of election in respect of Kotak Bar Association to be held on 29th March 2025. Election process started on 1st of March. I filed this petitioner,
opposite party number 4 in the writ application, and present appellant filed her nomination for the post of executive committee member on 9/3/2020.
Election was notified on
1/3/25, date of nomination of appellant 7/3/25, date of filing of writ application.
like that. I have not got so fast. You have to take old people along. Yeah. That last date for filing nomination.
Most probably it was 9. I filed on 7/3.
Well, 9.
Yes.
1/3/95 is the notification.
1/3/25
is the nomination.
Yes, madam. Nomination 9/3 I filed. Then thereafter, after scrutiny, my name was found placed in the list. Then thereafter, they filed writ application on 10/3/25. That is not
On what they were challenging in that?
That writ application was filed against the State Bar Council and the election officer to delete the name of the opposite party number 4.
Your client.
Yes, ma'am. Yes, she was contesting for the post of executive member. Her name was, after scrutiny, it found place in the electoral. Then they filed the case making the election officer that why you did not delete the name from the electoral roll of the State Bar Council.
One second. As of the date the election notification was issued, your name figured in the electoral roll?
Yes, 393, that is admitted then. So that they filed this writ application so late, and order was passed on 28/3 at about 4 o'clock, when the matter was not in the list even. 29th election, when I was putting flex and all on 28th, by 5 o'clock, that order also notification I have filed, that election officer has said that now it is not possible to remove her name by defaming the opposite party number 4 present appellant. There was an order that was affixed in several walls in the premises that don't vote this petitioner, that opposite party number 4.
Then whether election took place?
Yes, madam. Because I
am asking.
Yes, madam. Election took place.
When election took place?
29th, not after 16 hours. Next day.
29/3/25.
Yes, madam. By 7 o'clock, election started.
But the election is over and those XYZ have been elected now.
Yes.
You are not, because you are removed.
Yes, my name, there was a notification by the election officer in view of the order passed and received at 5 o'clock, 5 p.m. on 28th, just before the election.
This is this. Let us take
notice I have given.
No, what has told you? You are not the High Court.
Yes, ma'am.
What you have to issue notice? We have to hear them. Then we can pass on.
Wait, 1 minute, your lordship may bear with me. In this application, writ appeal was filed. This writ appeal. Then thereafter, some order was passed. Wrong order was passed. And just 7 days before, that order was recalled. Because that review application order may be also there here, otherwise I am having. Thereafter, on the order sheet, there is mention that notice should be received by the respondent number 4 who is appearing for the...
You mean to say we need not issue notice to them at all and straightway we should allow the petition?
May I take your...
we do not know. You are saying something give to us.
No. Your lordship is always right. But I have given notice and received copy. I am having, we have filed in the court.
That's sufficient.
It is up to your lordship.
No,
now delay is matter.
Your rules say, I am not the author of your rule. Your rules say, after the prima facie case is found in the writ petitions, the Lord has to issue notice to the other side, hear them, then pass order. We cannot violate the law.
They are appearing.
Therefore, we will issue notice to them. issue emergent notice.
My
Mr. Agarwal, you are here. Mr. Agarwal is appearing for the. Oh, you received notice.
2 and 3, they have also received. Receipt copy is there with me.
But you have to issue notice or not?
Okay. That
Otherwise, that our
your lordship should understand my predicament because another election is ensuing. So what?
that it happens in always election.
This because
But I was appearing for the election petitioner in the writ petition.
Who are you, advocate on record?
In the writ
As a
petition,
senior advocate or advocate on record?
as a senior come.
Then you cannot take it. We lost. You have no role. Issue notice. In addition to taking usual steps, learned counsel Shri so and so, who happens to be the advocate on record before the learned single judge for the opponent, is accepts notice. For OP number 1. OP number 1. There is only one. How many OPs are there?
The four.
4.
Issue emergent notice to rest of the OPs.
That also
Since the matter lies in a narrow compass, post it after service of notice.
date may be fixed.
No date.
Because my lord,
That
check,
time.
the ensuing election is coming. That I have
Date can be fixed at the admission stage. Because that will give an impression to the public that these judges are interested in the matter. So notice has to go and come. That is what
yes
the
only
Supreme
that
Court
is to be corrected.
Next.
Item 6. 6 my pardon, this case my lord said the senior advocate is to be engaged. So
What time?
yes, no,
Item 6. The request of.
next week.
Item 7. To seek time, you cannot tell that which time it should be taken. It is our domain. We come to next. When matter is posted, you are not reading and asking for the time. When we fix time, we say it should be next week.
Because of I'm playing with seeking my lord, the senior advocate will engage.
You have said they have passed the order. Call next week at the request of next week. Next.
Item 7.
Item 7, Lordship. I am for. Item 7, Lordship. Here, Lordship, the petitioners, the Department of Post, they have preferred to file this writ application
Can you
challenging.
be louder?
Lordship.
Because many students are sitting, interns are sitting, public will be watching.
Lordship.
They should feel that you have argued something.
Actually, some soaring throat.
Do you want water?
No. In fact, I was on the point to pray for an adjournment, but I will place this case here if required. Lordship.
It will give you.
Because of soaring throat,
We'll call it next week.
I will be grateful.
Next week.
If second next.
But that should say for the opponent, on health ground.
Grateful, Lordship.
Item 8.
Sir, ask you some students. For next. 8.
My lord, in this case, I am challenging the Hon'Ble CAT's order dated 25/6 to the 25 Monroe Annex, sir.
Second MCP.
My lord.
There are notice pending. Many matters are pending. Issue emergent notice. First off, in addition to serving copies of the petition on learned DSG, Mr. DSG, can you request it to accept notice for the OP1 Union of India? Railway is also there. That will separate.
But railway will appear.
You appear for railway.
Yes, But Mr. Sethi is appearing, but he is implement the name by name.
No, which one? I am challenging the CAT order. All
I am the petition.
I am the petitioner. My lord.
This of private capacity, they have implemented the concerned officials as the opposite party.
Then notice has to
Notice has to.
issue emergent notice. Learned DSG Mr. Fari is requested to accept notice for OP number 1 Union.
Item 9.
I've challenged the order dated
CAT order.
26/2025, passed by the CAT Cuttack Bench, Cuttack. The fact of the case is like this.
Why you went to CAT? Why you wanted to tell the CAT?
I am for Union of India. The order was passed. I have challenged that the
respondent, the opposite party here, my lord, remain absent from service duty from 1/6/2023
To 16/1/2015.
16/1/2015, my lord.
Yeah.
And thereafter, because of his absence, a proceeding was initiated, major penalty charge sheet was
Of removal.
Yes, no. Thereafter, he was removed from service. Against that order, 4 years after that order, my lord, he filed an appeal before the competent authority. And the appellate authority, what they did, they modified the order. The order of dismissal was modified to compulsory retirement with all benefits. My lord.
How many years of service he had put in?
He had since 2002.
And he put in qualifying service for pension.
My lord, since 2002 he joined in service.
No, I'm asking a question. They're asking a question.
Yes, my lord, he was having more than 10 years of service to avail pension.
Yes, 10 years qualifying service is 10 years in central government.
Yes,
What is it do?
10 years.
Issue emergent notice. You are sought for interim order.
Yes, my lord. The content proceeding is initiated, my lord. That is.
An application in IM pursuant so supported by affidavit saying interim protection pending dictate. First up, having heard that counsel say so and so and having perused the petition papers, we are of the considered view that interim protection needs to be granted to prevent injustice being caused to the petitioner's hearing. First, no prejudice will be caused to the other side if limited interdiction is ordered. First, in the above circumstances, application having been favored, interim impugned order of the impugned order of the CAT is stayed till next date of hearing. Next.
Item 10.
Very pleasure. In the case of the Union Benefit Party, the crux of the issue is that notional pension. The impugned one is page 18. The annexure part will learn Central Tribunal. The order was start from the annexure 1, but the last.
The pay and consequential pension.
Yes.
And other pensionary benefits after granting the
Yes.
notional increment.
No, notional increment. What happened, my lord, in many of cases now coming, suppose a person is retiring on June 30th or before that date.
And effective date is 1/7.
1/7. Also is correct. In Supreme Court may see page 101.
Requires consideration. Issue. Judge notice. Returnable within 4 weeks. Any interim order you have sought?
Yes, ma'am. That's the
Returnable within 8 weeks. First, an application supported by affidavit is moved in high number so seeking interdiction of implementation of the impugned order. First, learned DSG Mr. Pari argues that when the increment accrues the following day of retirement of the employee, whether retiree is entitled to that benefit or not is the crux of matter. First, several high courts in the country have taken conflicting views, varying views on the issue, and therefore the same merits deeper examination at the hands of this court. First, the case is made out for issuance of the granting of interim protection. First, next one. In the above circumstances, application having been favored, the impugned order of the CAT is stayed till next date of hearing.
May I request one thing?
Yes.
The Supreme Court is fixed the cutoff date is 1/5/2020. That may be mentioned.
He also says the decision of apex court
In civil appeal number page 101. First paragraph. Yes. Both the cases.
10 and 11.
10 sub-item 2. With
Sub-item 12.
Yes.
Same.
Yes, sir. I'm passing this slip into one case.
item 11.
Item 11, may I please lordship, I am VC lordship.
Yes, sir.
Last occasion, Miller's directed to file the affidavit which was filed under section 14(1)(b) of the Surface Act. Lordship kindly glance page 16. That is page 16 to page 20. The affidavit.
Have you complied with the interim order? Any interim order was directed?
No, Lordship.
What was to be completed?
That
We wanted to see the.
9-point affidavit.
Yes.
Lordship, 9-point affidavits as per 14(1)(b) of the.
Why we should undertake examination? You show bona fide by depositing 50% of the amount.
Lordship, the property has already been sold out.
Huh?
Absent purchaser.
Your auction purchase.
Your bank purchaser.
And for the bank, in this petition, I am preparing for early disposal of the petition pending before CJ.
That is still pending. 14 application is still. Yes, you appear for whom?
My lord, your lordship kindly see page 16. I have filed intervention application. The intervenors are the legal heirs of the mortgagor. So in this writ petition, without even in section 14 application, my learned friend has implicated us. In the writ petition, he has not implicated us as parties. So I have filed my to implicate us.
You were party there?
Yes.
In 14, you are party?
Yes.
Why you have not implicated him when he was a party before the learned magistrate?
Lordship, my only prayer is early disposal.
Correct. But he may have a ground to resist the early disposal. We do not know.
That permission. But
My intervention application, your lordship allow it?
Kindly say, sit down. We'll consider. The short grievance of the lender bank, which happens to be the petitioner in the case, is as to the long pendency of section 14, application filed under section 14 of Surface Act 2000. First appeal. Learned counsel for the petitioner vehemently argues that in the view of a catena of decisions of the apex court, the disposal of coercive action under section 14 at the hands of the magistrate has to happen within the shortest possible period, 60 days being the longest.
Lordship.
First up. Learned counsel.
The judges bench, your lordship kindly for a moment.
Appears for the borrower and opposes the petition, contending that his client has not been made arrayed as a party to the petition, though he is a necessary party in terms of decision of the apex court in Rajia Begum or Shanawat Begum, AR 1958 SC so and so. First up. He also contends that his client happens to be a party in the proceedings before the learned magistrate, and therefore he should be permitted to all the points that would figure in favor of his claim. First, next part. Having heard the counsel from the parties and having perused the petition papers, we are broadly in agreement with the submission of the counsel for the petitioner that the legal imperative for the magistrate is to dispose of the subject application in a time-bound way. Of course, after giving an opportunity of hearing to the borrower.
Borrower and the legal heirs.
Borrower or their legal heirs, as the case may be. First, in the there is absolutely no justification for keeping the subject application in limbo for an indefinite period. First, the magistrate has to take the call on the subject application immediately after giving an opportunity of hearing to the borrower stroke his legal heirs. First, next time. Ordered accordingly and petition is disposed of, fixing a period of 6 weeks for disposal. All conditions of parties are kept.
Lordship kindly bear with me that 60 days it is not mandatory.
Anyway, we are telling it. We are telling it should be within 6 weeks.
No, that 60 days it is not mandatory.
Still, we are saying that.
3 judges bench of the Hon'Ble appeals.
We agree with you. We are fixing the date.
And so far as the fixation of time limit in the constitutional bench in Allahabad, High Court Bar Association versus State of UP.
Court should not fix ordinarily the period because
In
it's not
extraordinary
considered as
urgent
final.
cases, court.
Yes.
Next.
Item 12. Item 12.
Mention impleading of tickets. As of application of appeal. Yeah.
Item 12.
12 also, Lordship, I am appearing for the OP number 1, Lordship.
Ah. This matter. Yes. OP number 3.
I mean, you got to file the objection because the recently person, last occasion, my lord has passed a specific order to provide a copy of the condemnation application which was filed before the DRT Kolkata. So now they have served some affidavits. Whether that I have verified the document, that particular document as per the order dated 22nd, 12/2025, that I has not been affixed to this affidavit.
Anyway, that is there. Give that copy.
Sir, I will file it.
What is this matter?
But in this case, I am appearing for the Bank of Baroda, though a notice was sent, a letter was sent, but no writ petition copy is served.
Give writ petition copy. Who appears for the
My lord,
petition?
I am for the petitioner Borgo.
Give copy.
Pursuant to the direction of this honorable court, I have duly instructed my junior lawyer to serve. I cannot understand that these are the new stories that I am facing now.
Give no story.
I'm sorry, my lord. I'm sorry, my lord.
Give copy to him. No story. Nothing.
It's a fact.
We have no control over your juniors. You have not taken our permission while appointing him.
But
Yes. Petitioner to serve copy of the petition on all the counsel appearing for all respondents before sunset of the day, failing which the petition may be rejected on that ground itself. The bank, we are for the bank.
I am for auction purchaser.
The auction purchaser shall, that is copy which you had filed. No.
Lord,
This copy you are showing.
this is the order copy, lordship is judicial.
No, that is
May not be.
well.
I go to the notice.
Next week. You now notice is already ordered in this. No.
Notice, no,
Issue notice. Then this order. Yes. Yes, immediately you have to give.
my lord,
Otherwise it stands rejected.
my lord.
Yes.
obliged.
Item 13.
If I may please your lordships, my lord. My lord, the petitioner is an MSME unit. And my lord, please have annexure 2 for a moment. Page 15. My lord, this is a go-ahead letter of the Department of Agriculture and Farmers Empowerment, wherein,
Cattle processing unit.
yes, a subsidy of 40% limited up to 50 lakhs. She shall execute the project through bank finance. The project has to be completed by 2021-6/17.
Correct.
Please see the date, my lord, that it was given in 2019. Top left, date of issue. Like. So, my lord, then on 24th April 2021, I issue a letter, annexure 3, page 16, intimating them that yes, as per your letter, now my work is complete. I am entitled to subsidy. Please do the needful in releasing the same. My lord, for more than 4 years thereafter, till date, the subsidy amount has not been released. And because of that, 50 lakhs, my lord, today my unit is in distress and I have been issued notices.
Two options here.
My lord,
We will issue notice to them if you want.
my lord.
Well, otherwise also we issue notice them and tell them to take call on your representation in a time bound way. Are you agreeable with that?
My lord, they have already done the verification, but till
So
date,
therefore, we tell them to take a decision and communicate it to you. Otherwise, they will keep it endlessly.
my lord, that your lordships can direct, but at the same time, my lord, my property will be auctioned on 27th. So that is also there.
27th of
January.
this letter you had,
I had issued it to them since.
you take notice, conductor.
Let's say I am for 1 and 2.
Issue emergent notice.
Corporation is there, bank is also there.
Lordship, high banks lose.
Under frame of the DSC accepts notice for opening.
1 and 2, my lord.
1 and 2.
One.
Yes, my lord. The applicable is the corporation, my lord.
Yeah. You appear for whom?
Bank of Baroda also.
Sri so and so appears for
4 to 6.
4 to 6. The issue emergent notice to 3. Returnable within 4 days.
Your Lordship. But I have an interim application.
Thank you.
My Lord, I'll make certain payments, Your Lordship. May kindly.
Next.
My Lord, I'll make certain, Your Lordship, I'll make certain payments. My Lord, as on date, the outstanding, my Lord, is.
In fact, you know that once 13.4 is issued, you have no cause.
Supposed to, actually. Still, we want to assess certain things.
Give to me copy.
You copy of the.
I will give a copy to my learned friend. My Lord, any kind of protection, my Lord, subject to outcome of the rate application. My Lord, I'll deposit 50%, Your Lordship.
You will deposit 50% of the amount due.
My Lord, if that is what has to, my Lord, to show my bonus.
You deposit 50%, even if subsidy is given to you. What would have been the discount?
My Lord, 50 lakhs comes down. So, my Lord, around 40 lakhs.
40 lakhs.
Yes, 40 lakhs.
40 lakhs.
My Lord, I'll deposit half of that.
Why? Even if you are entitled to the subsidy,
My Lord,
that remaining amount has to be paid by you.
my Lord, my Lord, that
So simple.
that is a fact, Your Lordship.
Then that is arithmetics, which we are taught at the age of 10, 12 years.
Your Lordship may kindly grant me that protection, my Lord, within 2 installments.
The counsel for the petitioner versus the interim application supported by affidavit in IA number so and so, seeking some protection with regard to the imminent auction scheduled to be held on
27th January.
27 January 2026. First time. When we asked as to whether he would show bona fide by depositing the entire amount minus the arguable subsidy, he very fairly agrees to do it. First time. If that is done, no prejudice will be caused to anyone. Even if the imminent auction is made subject to outcome of the writ petition. First, next one, in the above circumstances, application having been favored, the auction scheduled to be held shall go on short of confirmation and subject to outcome of the petition, provided that the petitioner deposits entire money with which respondent? Back number 4, in the OP number 4. 4. Before the auction date. Yes.
My Lord, in a
And
no,
not otherwise.
yes. My Lord, may I pray for in a no lien account?
Huh?
In a no lien account.
No lien account.
Yes, because what they'll do is, in case, my Lord, the subsidy does not.
This amount may be credited to the no lien account in accordance with the normative process of the banking.
I'm so grateful for your Lordship and
Item 14.
Lord, item 14, my Lord. The auction is scheduled for 21st.
Same case.
My Lord, a different case. Here, my Lord, what we challenge is saying that because of 31J, because almost more than 80% has been deposited, so surface proceedings would not lie. Because your Lordships will kindly see the demanded notice 13.2, my Lord, Annexure 1.
But my brother's bench has held a bench comprising of my brothers. This one, we should not interfere in this matters at all.
My Lord, that I bow down, my Lord. My Lord, may I pray for 20, my Lord.
Bapna.
My Lord, that, my Lord, I'm only at your Lordship's mercy, my Lord.
No, the writ court is not a mercy court. That equity courts will have, but in while exercising the jurisdiction, we take into account the elements of equity also.
Your Lordship. My Lord, the outstanding is said to be 62 lakhs. I have made deposits of more than 83 lakhs.
The question is not that. 62 was taken when?
On 2019.
2019.
Your Lordship.
What is the rate of interest?
My Lord, according to them, my Lord.
It's a commercial rate.
Yes, Your Lordship.
What is that? 18%? 24%?
Lord, it is cash credit.
Cash credit.
Cash credit, yes.
Well, still interest will be
9% to 12% around. 9 to 12 around, Your Lordship.
May not be there. Because Justice Dalway Bhandari's judgment says in all commercial transactions, the interest should be 10% in excess of the contemporary banking interest. Even if bank's interest is taken at 6, 8, 9%, 10%, that will be 18, 19%. What is the amount due now?
My lord, as per them, it is 20 lakhs. As per
20
the
lakhs.
20 lakhs, 19 lakhs odd. As per the sale notice, my lord, this is a poor person. My lord, I'm willing to.
Briefly, is for India is elected by poor people only. What to
My lord, 5 lakhs, my lord, because the auction date is day after tomorrow. I'll deposit 5 lakhs by then, and subject to outcome. If your lordships can protect me.
10 lakhs you pay, we will issue notice and make the auction subject to outcome of the petition.
My lord, if I'll only request for 5 lakhs because that is my instructions.
You have in fact prayed for us,
My lord,
before us.
I can limit your lordships.
Issue emergent notice, returnable within 2 weeks. First off, Learned Counsel for the petitioner draws our attention to the application in IN number so and so, which is supported by affidavit. First off, the prayer for interdicting the scheduled auction is sought for in the said application. First off, ordinarily, the Apex Court has said that ongoing auction process should not be interdicted, more particularly sans conditions. First off, no prejudice should be caused to the petitioner if the scheduled auction is permitted to go on as scheduled. Of course, subject to outcome of the petition. First off, counsel for the petitioner very fairly submits that his client would deposit 50% of the amount. When you will deposit?
My lord, 1 month time.
1 month. No, it should be before the auction.
My lord, auction is day after tomorrow. My lord,
But
that
you
is why.
came late to the court. What to do?
My lord, I can only pray for 5 lakhs by the auction date and another 5 within a month's time, my lord.
What do you feel now? Deposit a sum of rupees 10 lakh. 10 lakh. If a reasonable period is granted to gather the money and to pay. First of all, it is next paragraph. Next part. In the above circumstances, the application having been favored, we make the following interim order. One, the scheduled auction shall go on as scheduled. Semicolon. However, the same shall not be confirmed until further orders of this court. First. Two, the benefit of this interim protection avails to the petitioner if he deposits a sum of rupees 10 lakh with which agency?
Lord, Bank of Baroda.
With OP Bank of Baroda in 2 equalized installments, reckoning from history, failing which not only interim protection withers away, but petition also runs risk of dismissal on that ground itself. Okay.
Lord, may I also pray for no lien?
Sir?
To mark no lien, my lord. Pray for no lien.
Yeah. Then other depositing the ruling. Okay.
I'm grateful, my lord.
Item 15. You appear to be a very wise advocate. Yes.
May I please, your lordship? I'm appearing for Mr. R.K. Patnaik for
Yes.
OP number 1 and 2. Kindly have a glance on the noting.
Huh?
Kindly have a glance on the noting where they have given that opposite party, who is the LIC, has served the affidavit on the appellant and other parties. Respect of regular asking for them, they are not serving us a copy.
They are not
I
selling.
am on VC, my lord, for LIC 3, 4 and 5. And I am VC. I would serve the copy. I should okay. The counsel for the OP number 1.
Given the copy, take up now. Pass over.
My
Hello?
it will taken up 2 days after.
Because Learned Senior is there.
Actually, my learned senior is there and he's
For giving copy. For giving copy, he is not being palkiwala here.
Copy
You
I
can
will
give. Xerox it and give it.
That I will do. But my lord may keep this matter on Thursday
We will
kindly.
give you that date or
My
some
lord.
other reasonable
My lord.
date. First, you give the copy and come back. Oh, just.
I am to serve. I am for
responded 3, 4, and 5, pursuant to a Lord's order dated 5 and 6 of August, I have filed 2 affidavits. Then
4 days delay. I filed that what is on merits?
Merit of the case that the differential error salary of the teacher, though regularized late by the there was an observation of the Supreme Court, but that was taken as direction. So this is the case.
Observation is what?
Observation is that not taken into account while considering the single bench before the Honorable Court about the payment of certain salaries. That is only observation. First we can come to the
Where is that observation?
manner.
That is your first point of argument, and still you are not able to lay your hands on that.
Manner.
Because there is no concept of bringing the chit, palm chit,
So you come
turning the pages one after another.
You come to your point number D in paragraph 2.
Manner.
That was the observation call. Which affirmed the regulation of Dana Shiksha and directed the provision of benefits. This is 3 scores or the reproduction.
Kindly
Directed the provision of benefits for the period of service from 2008 onwards
manner.
for purposes of career advancement and terminal benefit.
Manner.
It's not observation.
No.
No, manner.
What the apex court said, show that from the judgment. Order of the apex court in SLP number 13627 of 2021.
Kindly take it tomorrow when I'll file that.
Or next week, if the request now.
A copy of the appeal memo has not been served.
Sir.
Cannot come at all. Manner sir, 115 January 26. I have served. Copy already served. If then.
All right, you convince us. Let's call next.
Item 17.
My lords, here the appeal is by the state. There is a delay of 234 days.
254 days.
34, my lord.
34 days.
My lords.
Then we will pay rupees 2,350 to the respondent. Then we will hear you. Brother, we will allow that application. Receive 2,500 now. Then we will hear you for admission afterwards. All right. The state appeal, inter-court appeal, is filed after booking a delay of 234 days. First off, an application supported by affidavit is filed explaining delay, which a little on the side of plausibility. First off, learned State Counsel Mr. Behera submits that there are arguable points in the appeal, and if delay is not condoned, the state would be put to prejudice. First off, they also adds that if delay is condoned, no prejudice will be caused to the other side. First off, counsel appearing for the respondent submits that, private respondent submits that the explanation offered is not plausible, and still application may be allowed if on a payment of compensatory cost. First off, we agree with this. First,
Next one. In the above circumstances, application having been INMS having been favored, delay up to 34 days proved in filing the appeal stands condoned, subject to the appellant, which appellant will pay?
My lords, may I say appellant number?
District Education Officer.
My lord.
Appellant number 3, paying a sum of rupees 2,500 to the OP numbers 1 and 2. OP number 1, you can say. There are 2 persons, na? Of the 250 to each of the respondents within 10 days, failing which application stands rejected on its own, and as a consequence, appeal also stands rejected.
Item 18.
My lords, item 18.
Yes.
Here the delay is 32 days.
Yes. What is the matter on merit?
Matter, my lord, regulation, my lord. Petitioner is at the verge of retirement, my lord.
My lords,
Retirement, my lord, 31/5/2026.
my lords, the petitioner was, there was no sanction post at the time of
entry.
My lords.
Entry point is?
Yes, DLR in 1994.
Take up that now.
My lord.
Can you take up that point now? What Jago says?
Jago is also, my lords. Jago says the appointment should be against a sanctioned post, my lord.
No.
That is para.
We have interpreted Jago. Myself and Sousa have interpreted Jago saying that if it is for 2 decades or 3 decades, the argument that the engagement was not against the regular post is irrelevant.
Well, this is also.
Do you have that?
My lord.
My lords, para 26 of Jago.
26?
My lord.
6. Treatable.
It categorically held that the employee
Held the day before yesterday also. We have held. That
And
once,
another point is that post was abolished since 2015, my
then
lord.
why did you continue? So when it amounts to saying under section 58 there is admission. If you say post is abolished, then it amounts to admission under section 58 of the Evidence Act.
That, my lords, the Honorable Single Judge has not dealt with
No, it's a question of-
only.
All right, there is an error. But that is not sufficient for our interference. We should show judgment is not sustainable. Always there are errors, grammatical errors, linguistic errors, maybe legal errors also. That will not be sufficient for appeal.
My lords, one more submission, my lords. Now he claims financial benefits and what I humbly submit, my lords. It may be fixed notionally because the post is not there.
Where is the legal flavor in your argument?
My lord, since there was the appointment itself was illegal, and because of the long continuance, if any duty is granted.
That's what. Who did illegality? They should suffer. He did not jump into your office all of a sudden. You took his services. You exploited his blood, bone, and flesh for all these years.
My lords, may I record my submissions. First is that there was no sanctioned post at the time of initial appointment. Another thing is the post was abolished since 2015 and the application was filed in 2020 for regularization. Since there was no post available, the
regularization cannot be granted. And there should be existing vacancy at the time of initial appointment.
No, that we have not, we do not. This is your contention, but all these contentions are covered by the judgment. Why we should repeat and waste our time?
And there was no selection process adopted.
That is in a very the selection process in regulation cases.
That is what is dealt in para 26 where that is.
Stagger itself. Yes, agreeing with this.
Item 19.
Item 19. My lords, there is delay of 175 days.
Tell us on merit. In all your cases, there is delay. We always assume that way. Yes. What is the merit? Why, Mr. Mehura?
My lord.
Why unworthy appeals are filed?
Yes, my lord.
Increase the pendency.
My lord.
Unworthy appeals are not to be filed. That's what the apex court said. And very graciously, your advocate general, appearing before the apex court, has given quite a set to 900 cases on that ground. It's on record. What is the point in this?
My lords, here is same thing, my lords. He was appointed as work Sarkar in a NAC, Notified Area Council. Is
recovery from the authority.
My lord,
2017.
My lord, there is no recovery order.
2017 retired.
Withholding.
For refixing.
That is also recovery.
No, my lord. So far recovery party is concerned, Rafiq may see your lordship. But if it is some wrong or illegality is committed, it can be refixed.
How?
Because after 3 years of retirement.
After how many years of retirement?
3 years.
3 years.
Yes.
Yes, covered by Rafiq Masina.
Has the employee contributed to this? If he has not contributed to this, then
question will not arise. As my brother says, suppose if there is some fault, some fraud, something like that, then we understand. Otherwise,
no, my lord. So that it was pointed out by the audit that objection that it is wrongly fixed.
Dismissed, agreeing with the reasoning of the learned single judge. Okay.
Item 20. Item 20.
Yes.
Discuss 366 dilemma.
366. What is this matter, brother? Can you make a statement to the court?
Say my prayer person.
Right?
Under these circumstances narrated above, it is therefore.
No, which are those circumstances? We want that now.
Call for the records double page number 19132 of 24.
That is prayer.
Prayer person.
Not prayer. What are the fact matters on the basis of which case is decided?
After completion of 30 years, the petitioner has not received his third RSP minor. After that, I have filed an WPC case, hearing number 32.
19132 of 24.
Minor. Wrongly, that has been withdrawn by me.
Withdrawn?
Withdrawn.
Wrongly, who withdrew it?
Minor.
Who withdrew it?
I have withdrawn. After that, I have filed second writ petition, my lord. In that, page number 42. Order has been passed.
Number 32.
42. It was also withdrawn, my lord.
198-2024.
Yes, ma'am.
Land counsel for the petitioner.
And there is a warning. Petitioner is also cautioned not to approach once again by filing this type of application.
That has not been withdrawn by me, my lord. Court has
so much to withdraw.
My lord. So forced me to withdraw this case. My lord, call for these records 19132 of 24, my lord.
No, then you have to make application before the same judge. I never agreed to withdraw. You have written like this wrongly. Therefore, recall that order. Because what happened in the court, we do not know.
Allow me to file a fresh writ appeal.
No. There is a reason for the learned single judge. He is appointed at the hands of the president of the country. He is not some JMFC. He has made that observation. And now that virtually, that may be true also. We do not know because we don't want to say more. You withdraw this appeal. We are only thinking aloud. We are not even suggesting. Because in Supreme Court, you may say that we forced you to withdraw, as you are saying against the learned single judge. Therefore, we are thinking aloud, only thinking aloud, nothing beyond that. You have to go before the same judge and say that I never agreed to withdraw, but I was misled to withdraw or forced to withdraw. Therefore, withdraw your order, recall your order. 91 Supreme Court will permit you to do that. Otherwise, we are dismissing the petition. There is nothing. Because that single judge has written this. First also you withdraw. That first also was forced withdrawal. Then if we force you to withdraw, you will withdraw. You should not agree. Judge may say, Andre, not thing. You should say, why not I am not agreeable to that proposal.
That mistakes to by
Then what can be done? Go before the same judge. The net counsel for the appellant having a petitioner, a petition it is. Appellant having argued the matter for some time, very fairly submits that he may be permitted to approach the learned single judge who has handed the impugned order, seeking its recall or recall on the ground that it was not the intention of his going to withdraw the writ petition at all. Personally. In the above circumstances, leave having been accorded, appellant is permitted to approach the learned single judge for redressal against the order in question, for recall of the order in question, recall for review of the order in question. First, in that connection, all contentions are kept open. Next.
Item 21.
Item 21, Lordship. Here, Lordship, the intra-court appeal is prepared by the petitioner challenging the order dated 13th of August, Lordship.
The petition was dismissed.
Dismissed, not dismissed, Lordship. In fact, honorable single judges were dealing with the matter. The case is that, Lordship, the petitioner, after being prosecuted under a criminal proceeding, has a department proceeding also. In the criminal proceeding, he has been acquitted, having no merit in the criminal case. Thereafter, in the department proceeding, the authorities have felt it proper to give a black pack punishment, so also the period of suspension. And accordingly, it was challenged to honorable court. Honorable single judges were dealing with the matter.
It's a Ramlal case.
No, not exactly, but I am relying on the position decided in the GM tank case, Lordship. There, where the honorable court has been pleased to say, honorable FS court has been pleased to say that when there is no other things coming out in the department proceeding as of the criminal proceeding, and in the criminal proceeding, when the trial court has been pleased to acquit that, given an order of acquittal, then
you are citing old decision. I am citing late.
Then I will pardon, Lordship. Absolutely. So that is what I think. But while honorable single judge dealing with the matter, at Annexure 1 has been pleased to observe that so far the black pack portion is concerned, that was not been dealt with by the honorable single judge, but the period of suspension was dealt with as a period of leave.
In other words, for the same misconduct, you were proceeded against in a disciplinary inquiry.
Yes,
you were also charge sheeted by the criminal court.
Yes, Lordship.
That eventually resulted into acquittal. Is it a case of honorable acquittal?
That's exact word is not there in the judgment, but
it may not be because honorable acquittal idea may not be there in the
to establish charges laid by the prosecution.
No, that will not. Take out PV Rudrap or State of Karnataka. Then the court has laid down 4 principles. Then it will be a case of honorable acquittal. After referring to round law, if your case fits into one of those, then you have a case. Otherwise, not.
That's
Go to Karnataka. P.V. Rudrapur, State of Karnataka. Yeah, give the citation of this decision. You just look into it and come back to that.
Right. Here, let's say serious delay is also there.
Huh?
3 days delay.
My judgment is that. My Lord's judgment is that, and you just keep a copy of that. Invariably, will be. Every day also.
Just very often. Just give copy of that.
I will arrange it.
Call next week.
Get fullers.
Item 22.
No, this is an appeal by the state, booking a delay of 203 days. 203 days, my lord.
Yes. What is the
the merit?
merits, Mr. Panda?
Merits of the case, my lord, at the impugned order, paragraph number 5. Paragraph number 5, Lordship, Honorable Single Judge has directed for consideration of the case of the petitioner, that respondent, in the light of the Pradeep Panigrahi case. So, my lord, without
the case for you. It's a consideration.
Yes, without recording my concession, your lordship may direct that no infirmity in the order.
This intra-court appeal by the state and its officials calling question a learned single judge's order dated 29/1/2025. Passed in respondent's WPC number 2050 of 2025, wherein the operative portion reads as under. Next paragraph. Next paragraph. Learned State Counsel Mr. Panda, appearing for the appellate, vehemently argues that although there is a short delay of 203 days in filing the appeal, a plausible explanation has been shown for condonation thereof by filing IA number so and so supported by affidavit. He also tells that the learned single judge grossly erred in following the decision in Ashok Panigrahi.
Pradeep
Kumar Panigrahi. So and so. First, the explanation offered for the delay proved in filing the appeal, we do not find to be plausible. First of all, in almost every case coming before this court, filed by the state, there is invariably delay, at times long delay. First time. For the purpose of limitation law, state does not stand on a preferable footing for the citizen. First time. Be that as it may. The decision of the impugned order of the learned single judge only directs consideration of case of the OP respondent in the light of a particular decision, namely Panigrahi Supra. First time. Nothing more is stated. First time. In matters of the kind, ordinarily intra-court appeal does not lie. First time. Next paragraph. In the above circumstances, appeal being devoid of merits is liable to be rejected in limine, and accordingly it is first registry to send a copy of this order to the respondent by speed post immediately for his knowledge and action. Yes.
My lord, the appellants may be directed to consider the case in the light of the impugned order without being
the order to be implemented.
Yes.
As directed by the learned single judge.
Grateful, Your Lordship.
Time limit is not given by the learned single judge.
Considered to be considered.
No, that's all right. What is the time limit given for that?
Time limit
within 8 weeks.
Within 8 weeks. Your Lordship may fix up that time.
Yeah.
Because we are in appeal. We were in
from this too. Yes, we shall be coming back in a couple of seconds.
state is the only private respondent with a delay of 131 days.
131 days.
Yes. On merits, my lord.
Yes.
First, my lord, I have fourfold submissions to make. 2 on the technicalities of the order, which your lordship finds at page 19 of my brief, and 2 on the merits covering the claim of the appellants. My lords, if your lordships
First of the case before the learned single.
Yes.
Before the single.
The appellant number 1's wife was an ex-primary school teacher of the government, my lord, appointed in the year 1980.
Appellant
Number 1's wife was an ex-primary school teacher.
Excellent one.
She died in harness. She was an ex-primary school teacher.
So the first appellant is the widower.
Is the widower. The second appellant is the son.
Son.
Yes, ma'am.
Of
deceased wife, who was an ex-primary school teacher. Appointed in the year 1986, dies in harness during 1997.
86 appointed.
Yes, ma'am. 97, she dies in harness.
After 11 years.
After 11 years of service. Here I would take a pause, Miller. At that point of time, the relevant rule covering the pension and the death benefit and gratuity was Odisha Aided Educational Institution Employee Retirement Benefit Rules 1981.
1981
rules. In the year
rules relating to rehabilitation.
Relating to death, pension, death cum retirement gratuity, as well as pension.
DCRG.
GG.
DCRG.
Yes.
Pension.
And gratuity.
Triple benefit.
Yes, ma'am. That your lordships find under Rule 8 of the relevant rules.
Gratuity and pension.
Yes, ma'am. In the year 2000, the appellant number 1 applies for the same under the relevant rules.
In 2001?
In 2000.
2000, after 3 years.
After 3 years, he applies. Now, my lord, in the year 2005, after a lapse of 5 years, they disburse, annexure page 37 and 38 of my brief. They disburse the final pension order and a gratuity amount of 40,000. Now, here is a
DCRG.
Malad?
No DCRG.
Includes all.
Including
DCRG. It was sanctioned and pending disbursal. The appellant number 1 remarries. Sends an application to the concerned authority that I have remarried. My son is the other legal heir. You disburse that claim to my son, who is the appellant number 2.
Whether law provides for that.
In the pension order, my lord, there was a specific clause that if he remarries, how the pension is to be calculated and to whom it is to be disbursed. I'll show.
Apportionment is there.
Yes. I will show your lordships from where I got the specific point.
Yes.
Now, my lord, the department accepts it. He calls from fresh pension papers from the appellant number 2, who in the meantime had attained majority.
Son.
At the time of death, my lord, the appellant number 1 was only 80.
That is till attainment of majority. Pension is payable till attaining the majority.
No, there is no such rule. I'll come to that.
I will be given an enter for.
Yes, he will give. I'll come to that, your lordships. So in the meantime, he attains majority. The department accepts that we will pay the appellant number 2, the DCRG and all the other benefits. That letter, your lordship.
All right, then go further. We'll believe you. We don't doubt.
Thereafter, Miller, that process goes on. They pass the balls between their courts. Several times they have issued letters, you give us fresh papers, we'll take action. No action was taken. I filed a writ application before this honorable. At page 19, the honorable single judge dismisses my application on a 1-line order, saying that a major married son is not entitled to get family.
That's our view.
Yes. Here I will like to pause for
attainment of majority.
My lord,
that could not have been denied to you.
I will pause here for a moment. 2005, 1 OLR 168. Similar question came up before the bench. I have prepared a list of citations I'll produce before your lordships. Similar question came up before this bench. Whether the family of the employee who is a government school teacher is entitled to family pension under the 1981 rules. The answer was affirmative, yes.
Son?
Family members, my lord.
What was involved in that?
I like to get to that. Now, Miller, my humble submission to your lordship's view is that once death takes place, succession opens. Once succession opens, my lord, under section 15 of the Hindu Marriage Act, I am the class 1 here. Now, my lord, there are two types of benefits, my lord. The terminal benefits that accrue on account of death, the pensionary benefits the person gets after superannuation. So far as the pensionary...
Brother, under section 50, you succeed at the class 1 heir of the deceased.
Yes.
So the estate of the deceased.
Yes.
Family pension is not in estate.
I bow down to that, your lordships. I have also got those Supreme Court decisions that run against.
Simple. Why? Any standard word like mens on Hindu law, mitra on Hindu law, mullah on Hindu law. They say that.
I'm aware. But so far as it relates to pension, not for the gratuity. I had twofold prayers. Now, one is pension, which was already sanctioned in the year 2005, calculated by the department, pending disbursal, so far as appellant 1 is concerned.
Appellant 1 is concerned.
1 is concerned.
Till marriage.
Marriage.
When he married?
He married in the year 98, Miller.
So he will be entitled to death for only 1 year.
Let the state
No, according to you.
Yes, my lord. If I go through the rules, my lord, that is the...
Accept notice. Yes, he is bombarding the court like... Very appreciable, very well.
Yes.
Issue emergent notice. First off, learned AGA Mr. Panda on request accepts notice for the number.
Respondents, my lord.
All respondents.
All respondents.
First, we'll fix a date. Otherwise, it will go on like this one.
My lord, 29 years in the meantime has passed. So, my lord.
Anyway, for appellant number 1, appellant is happy because he is married and in the lap of the other lady. This son has attained majority, therefore there is no difficulty.
It is only a bonus.
That's all.
The bonus I should get that, my lord.
In fact, in English law, we were told by our Professor A.J. Desai, a great teacher of tort law. He taught us 2 concepts. One is injuria sine damno, and damnum sine injury.
Injury without damage and damage.
Without that. 2 decisions he used to see. In injuria sine damno, there is no damage as such, but still
there is injury.
Right is inflicted. I don't remember that case where he wanted to exercise the right of voting and he was prevented. Then in cross-examination, he admitted, I wanted to vote for the candidate who has won the election. Then on that basis, they moved an application for dismissal of the claim. Then court said, no, his right to vote there is infraction of the right, even when the candidate has won, his candidate has won. So he called it as injuria sine damnum. It's like this only, I guess. Anyway.
Item 24. Lordship fixes a date.
After 2 weeks? 4 weeks. 4 weeks. 4 weeks. Yes. That's short matter. Short matter.
Wait, please, my lords.
Matter lies in the narrow compass, call after 4 weeks. So that AGA will prepare and come for arguments. Next. One sentence you heard. 1 second, brother.
1 second.
Cabinet Council, Sri so and so, appearing for the appellant, and who very effectively argued his points. First off, the case is made out for admission. First off, issue notice. Learned AGA on request accepts notice. Call after 4 weeks since matter lies in an order compass. We appreciate you.
I'm getting
Yes.
Wait, please, my lords. This challenge is against the order dated 21/11/25 of the learned single judge. Review petition for on grounds of delay. Delay was 370 days. The original order, 370 minutes.
370
minutes.
What are the explanation of
My lords, this is a peculiar case in the sense that before the Honorable Single Judge, the writ petition, the claim was to give this revised assured career progression scheme benefits. RSCP benefits for the post of junior assistant when the petitioner was not holding that post at all.
He was not holding that.
He was appointed as junior assistant in the year 2015. Prior to that, for 20 years, when he was entitled for RSCP, he was working as a tax collector. Now he is claiming RSCP benefits, that is great pay, of the post of a junior assistant right from the day of his appointment as tax collector.
Yes,
That was never
linked to that post.
that was never adjudicated, my lords. There was a direction directly to give him those benefits.
Take notice.
My lords, I'll take notice. My lords, there's a contempt application pending also. And
Is there a delay in filing the appeal?
no, my lords, there is no delay. No delay.
Third, learned counsel for the appellant. First one, succinctly, he submits that the RACP benefit is payable to an employee as against the post which he holds only and not other place. First, this aspect having been arguably not considered in the impugned order, the case is made out for admission and issuance of notice. First one. Counsel also submits that in terms of impugned order, contempt proceedings are taken up for its enforcement. And if that happens, this appeal may be rendered infractional. Next one. In the above circumstances, you are for
And for the respondent.
arguable cases. Lean to the point in question.
Yes, ma'am. Your Lordship, pursuant to order of this honorable court, pursuant to the order of this honorable court, in WPC number 26457 of 23, the government has allowed the benefit to the petitioner, but the Cuttack Municipal Corporation has not paying the same.
No, question is not that. Did you hold, had you lean to the post?
Yes, my lord.
Where is your
The RSCP benefit says, my lord.
No. The tax collector is at par with junior.
My lord. Since the petitioner and several other persons are continuing, my lord, in the same post, and pursuant to a committee, selection committee meeting held, and pursuant to the recommendation of the said selection committee, all the tax collectors have been permanently observed as a junior assistant, my lord.
Absorbed?
Yes, my lord.
Is it true?
No, not absorbed. Pursuant to order from this court, my lords. They were absorbed, yes. But from 2015.
2015,
my lord. G is claiming RSCP benefits prior to 2015.
Period also.
Yes.
Not me, my lord. There are several documents.
That is wrong. We have categorically written that
I have the copy of several persons, my lord.
No, maybe.
Have got the benefit.
Maybe.
That makes no sense.
Then if your hospital...
You were holding that particular post on absorption.
Yes, my
So
lord.
your right of lien arises after absorption.
No, my lord. The benefit, this honorable court directed, my lord. This honorable court directed that the back period should be counted for their absorption. Pursuant to that, if your lordship will allow me to say, my lord, then the annex of 16 of the writ petition.
Read that sentence.
Sri Srikanta Kumar Swai was not performing the job of junior clerk, junior assistant at any point of time, and as such, he was not eligible to appear the test in terms of the policy approved by the selection board. However, in compliance to the order dated 1/7/14 of WPC number 20363 of 2013 and order dated 19/1/96 in OJC number 1058 of 1997, passed by the Honorable High Court of Orissa and basing on the recommendation of the selection board, meeting held on 8/4/1999, government after careful consideration had brought over the petitioner in the vacant post of junior assistant. Therefore, his past service as a tax collector shall be counted towards his service and for his pensionary benefits, but there shall be no financial benefits whatsoever for the period of service already rendered. Then yes, it is ordered.
Already rendered.
Already rendered, my lord. Then the final conclusion of the government, basing on which the petitioner claims the benefit. So far, it is mentioned here that regarding sanction of RSCP, he has stated that so many employees of the Bhubaneswar Municipal Corporation have been allowed such benefit. In this regard, he has submitted the copies of order of BMC extending the benefit of RSCP to some employees, such as Sharat Kumar Panda, Vikram Kesari Samantaray, Manas
Mahesh Kumar Chand and Vichitrarananda Sutar, in view of the aforesaid premises, Srikant Kumar Swai is allowed the RSP benefits as per office order number such and such of BMC Bhubaneswar. The government has allowed. It is the duty of the CMC, Cuttack Municipal Corporation, to extend the benefit, for which this honorable court in a single bench, single judge has passed the order to extend such benefits.
When were you appointed as tax collector?
In 1994, madam.
No, date given here.
Date. 14/11/1994.
I am wondering, suppose if some satellite were to be launched from your Mahanadi, it will fall in that Mahanadi itself. Because time, date, nothing is worried. Nobody is worried. Only year.
No, madam, I'm just 14/11/1994.
11/1994. You are absorbed as
junior assistant.
When?
In 2015, madam.
No, again. 9/7/2015.
No, 1/7/2015. The order was passed.
1/7.
2015.
In the meantime, I was also promoted to the post of senior assistant.
One second. Now your RACP is in respect of junior assistant post or some other post, higher post?
No, man, just junior assistant. Yes.
1/7/2015.
Yes.
From 14/11/1994, you were working as what?
Tax collector.
Tax collector only. So for 20 years, 21 years about, you were not a junior assistant.
Yes.
Agree? Then, what the absorption order says?
Annex of 3.
What does it say?
In compliance to that was also passed pursuant to the order of this honorable court.
What does it say?
In compliance to the order number 17, order dated 1/7/14 in WPC number 203363 of 2013 and in order number 19/196 in OJC number 1058 of 92 passed by the Hon'Ble High Court of Orissa and basing on the recommendation of the selection board meeting held on 8/4/1999, government after careful consideration have been pleased to brought over the following tax collector of BMC Bhubaneswar in the vacant post of junior assistant and posted them in different municipal corporation as mentioned against each in the scale of pay of rupees 5,200 to 20,200 with a grade pay of rupees 1,900.
Which order says your previous service should be counted?
With effect from the page 26, my lord, pursuant to the order of this honorable court, the government has passed the order under Annex 5 of the writ petition, my lord. Page 26 of the writ petition.
But in this regard, order has already been passed by the government that his past service as tax collector shall be counted towards his service only for pensionary benefit. This is
not RACP bill.
Not RACP.
If Lordship will turn to Annex 16 of the writ petition, I have already read out in page 52, my lord.
But this is Annex 15.
Annex 15 is the order 16, my lord, basing on which the writ petition has been filed by the petitioner. Annex 16, page 52, the operative person. The government has allowed the benefit to several persons for which the same benefit.
Where is it stated? Your argument is one thing. Where the order sits?
The government order, my lord. Page 52 of the writ petition.
That order is annexed, my lords, in my brief at page 68, operative course. My lords, my brief, the writ appeal.
Karan Senapati, Principal Secretary.
My lord. Page 68, my lords, is the Director Municipal Administration. My lord, of the appeal, my lords.
No, this is the RACP. Senapati order is Principal Secretary.
Yes, my lord.
What does that say?
Yes. That one, my lords, it says, my lords will have page 31 of the brief.
We are not on same page, but although we are on same document, no issue.
My lord, I am placing, my lords, this is internal page 2 of the document.
Internal page 2 of the document. Yes, which paragraph?
My lords, the fourth subpara. Accordingly, the petitioners, well, I could get it. May I pray my lords may kindly take the writ appeal because I have annexed everything there, so it will be easier for my lords to refer. Writ appeal.
Yeah.
Writ appeal, my lords, page 31.
13.
Subsequently in compliance. That order.
Yes,
My thoughtful consideration.
Yes, my lords. Yes, upon giving my thought, my lords, I'll place from there only. Upon giving my thoughtful consideration, I found that while the petitioners, Srikanta Kumar Swai and two others were continuing as DLR tax collector, had filed a case before the Hon'Ble High Court by OJC number 13695 of 97 for regularization of their services in the post of junior assistant and were permitted to appear in the written test and viva as per order dated 25/9/97 passed in Miss Case number 11861 of 1997 arising out of OGC number 13695 of 1997 as per proceeding of the selection board meeting held on 8/4/99. A seniority list was prepared by the selection board where the name of the petitioners was found placed in the broadsheet at serial numbers 202, 203, 204 and their appointments were kept pending awaiting disposal of 13695 of 97.
What happened to that OJC?
Well, he was to be considered for that post. He was not considered. He continued as tax collector throughout.
OJC said what? That OJC order, subject to outcome of the OJC order. What the OJC order say?
The OJC order was for regularization of the services in the post of junior assistant.
With effect from which date?
That he did not say.
That will decide. That is the clinching part. That is the clinching part. Suppose if the OJC has said, as he said, that it is with retrospective effect from the date they enter to the said post, junior assistant post, then we have no case at all.
Then it relates back. Let me
relates back.
A short time I
have that copy of OJC.
No, just now not available.
Tomorrow we produce it.
My lord, kindly give me 2 days time.
Yeah. For producing the copy of the order in OJC number 13695 of 1997, disposed of on 6/11/2000. That will clinch everything. Number one. Number two, why are you singling out this employee? For rest of the employees have already extended the benefit. State cannot be taxed that way.
I am coming to that. This person was appointed directly in the post of junior assistant directly in the CMC, the Cuttack Municipal Corporation. His counterparts have been serving in the PMC. Now the CMC has repeatedly written to the PMC saying that if you have given that benefit to your employees, then that is illegal. Please reconsider, review, and
all are under the direction
is reconsidered. You have to extend the benefit. When reconsideration happens in respect of the entire flock,
my lord, if that
then I can understand.
It will be a perpetuity of illegality, my lord.
We don't. Certain things, then certain illegalities are to be kept intact because rectifying them will create floodgates of litigation.
This is only as regards that RSCP financial benefit, nothing else. Which is why, my lord.
Yeah. Of course, if the order copy is not produced, then adverse inference may be drawn in favor of the response.
Well, let that observation not be there. I'll produce the copy.
Otherwise, there will be no enforcement to the order.
No, my lords will hear
this thing. We will say one thing. You will say another.
No, my lords will.
You have said that you should have produced because that's a clinching evidence. For it may be in your favor also.
My lord,
we don't know.
Then, my lords, I'll pay for a little more time because it's OJC 1996.
2 days. Okay.
Item 25.
This is an appeal by the state involving delay of 61 days in filing the appeal below. 61 days.
What is on merits?
Merits, my lord, there's a peculiarity in the impugned order that the Honorable single judge directed certain things to be done, but being aggrieved by the which annexure we have already disposed of the claim of the respondent. That annexure was challenged before the single judge. That annexure has not interfered, it will not passed. That annexure remains intact. We have disposed of its claim already. Rejecting.
That contention is considered.
No, not yes. In the impugned order, it states that the petitioner challenges the so-and-so order, but ultimately it was not passed or interfered. My lord, in the impugned order, my lord,
It was a
petitioner.
certiorari proceeding.
Yes, he was in the certiorari proceeding.
Correct.
The petitioner is aggrieved of the office order dated so and so by the annexure, office order issued by the opposite party number 1. That is that his prayer is to pass that annexure.
16/9/2025.
No, 12/8/2022.
12/8/2022.
12/8/2022.
Which order now? 16/9/25 order is learned single judges order. Where is that impugned order? What was your prayer?
Page 50.
Because I am in cabinet, my lord. The copy of the appeal memo has not been served.
Please give copy.
Yes.
Call next week. In the meanwhile, copy of the
Next week, madam.
the appeal papers to be given to counsel on giving. Post after the papers are given and not otherwise. Okay.
Item 26.
Is the item 26 one part of
Item 27.
27, my lord. I pay for 1 week's time, my lord.
2 weeks on request.
Item 28.
Yes, Nani.
My lord, they are the appellant.
You are the appellant.
Yes, ma'am. Here, my lord, kind of a glance to the earlier order.
Next 1 means that also you can.
This present intra-court appeal arising out of a common order passed by this Hon'Ble Court, basing upon which this order was passed, that was State versus Devendra Deep. In that case, my lord, State has gone for appeal SLP to the Honorable Apex Court.
What happened to that?
My lord, it was fixed to
12.
It was fixed to 12 million of this. It is not taken and it has been posted to 19/3/2026. I may.
Your Lordship may kindly hear me. My Lord, Your Lordship may kindly turn to page 12/9/25. Order dated.
12/9/25 order.
Yes.
15/9.
12/9.
No, 15/9.
No.
It is 15/9.
12/9 order was
12/9 is also there.
Yes.
15/9 is there.
12/9.
There is no order in 12/9.
12/9 also.
12/9.
In Horofidi, in the next, my lord, in the next case.
No, we are in the first brief, my lord. The sub item is first item, same order, 15/9.
Yes, 15/9. Same order. 15/9, my lord, in that case, order, the Honorable Court was pleased to direct them to take instruction as to whether I can be appointed. Hello, what has happened? An advertisement was issued in 2020.
Anyway, matter is being examined by the Apex Court.
My lord, Apex Court, because similarly situated person have already been given appointment, why I should be deprived of?
That itself is being examined by the.
But they are working. All of them are working.
Correct.
It's
but, that particular matter which has been followed now by the learned single judge, that is being examined by the Apex.
That is true. But that person is also working, and apart from that person, many others are working. So why should I be deprived of?
Similar matter is being argued on the floor of the Apex Court. And therefore, call this matter after 6 weeks.
Decision 19/3, my lord.
19/3.
March 9.
We said 6 weeks. It will be 4 weeks. Just extra we have given.
My lord, may I pray your lordship kindly see that order, because they have been directed to
furnish information as to whether it can be
and they have filed one IA, your lord, an affidavit. Your lordship may kindly go through it.
Saying that it's affidavit filed before the Apex Court.
No, before this court.
This court also.
This on the was pleased to direct them. That is
Decision
1/11/25
saying
that Devendra Deep has been already been appointed And what they have stated, your lordship may kindly turn to paragraph 6.
I have given the details. Kind of a glance to para 8, my lord.
No, para 6, your lordship.
Let it be para 6.
Para 6, thereafter, your lordship may kindly. Para 6. About 8 persons are.
That was under the threat of contempt.
My lord, I have filed a contempt also. And because, my lord, they have stated that matter is pending. On that score, they are taking time for the last 3 to 4 months.
What not taking time?
Because matter is being argued before the apex court.
My lord, my submission before your lordship is that, assuming that, the fact is that matter is pending. However, all of them situated like me have already been given appointment.
You said it twice now.
My lord?
You have said it twice now.
Yes. Devendra Deep case, because keeping in view the Devendra Deep case, all have been decided. Devendra Deep and others are working. And this honorable court was pleased to direct.
That's all.
And because these two petitioners of my respondent.
Well, notice is issued in this matter.
Yes.
Yes, ma'am.
Before the apex court.
No, not in this case. That
Devendra
Deep.
Yes.
Lead case.
The notice.
Notice for admission. Can have a glance to.
Notice.
Yes.
Follow.
Lordship keeping it to.
No.
Lordship, am I keeping it to?
After 6 weeks. Yes.
After 29?
My lord, this is a matter where the petitioner was admittedly unwell and continuing under medical treatment removed from service on 28/9/2009.
28/9/2009.
My lord. Pursuant to a predetermined preconceived departmental proceeding, on the ground, the petitioner was unwell and he has chosen the hospital where he will be treated. That is the only allegation. And they admit that the unauthorized absence due to illness. They have admitted in the inquiry report, in the appellate order, in the revision order, that yes, he was unwell, but why he had not complied the order of the authority to go to New Delhi Group Center, Chhatkadolam.
Where he was working?
He was working at Assam.
In Assam?
Assam.
Where, which? Assam,
Soratpur. That is the group center. 189 group center, my lord. That is all the documents I have annexed, Annexure 3, 4, and they have advised him for bed rest. You go home on leave. 20, my lord. While he was in duty, that he was ill, and they have advised space 20, rest for 5 days. Then they have given me the leave, sanctioned my leave for further treatment. So when he was there in their home in Bulandshahr, UP, my lord, that is the eastern side, then he was communicated that I need some more time to join the duty. And when he joined the duty, there was a departmental proceeding. He was participating. And admittedly, there was unauthorized absence, but that unauthorized absence is not willful. So it cannot be a misconduct. That is the judgment of the Honorable Appellate Court.
Willful unauthorized absence is misconduct.
Yes, ma'am.
If it is not willful.
Willful.
But
and
because he is forced by some circumstance.
My lord, beyond,
it is not.
Beyond his control. And this last occasion, my Lord and Senior was directed by this court that whether by giving a lesser punishment, he can be inducted in the CRPF. That was the order. That is not exactly.
What was the illness?
My illness is very serious illness.
What is that? Tell me, we also know little medical science.
That illness is, my lord, in the order of the Lord and Single Judge that has been, I am not so medically
No,
I
it
cannot.
is seen he was in typhoid.
No, my lord. Salmonella. There is some different type in Assam. She was feeling weak and the legs and hands have become so thin. So
To Google and say what is that?
Salmonella.
Symptoms, effect.
My lord, that is in 83 page that has been written. Paratyphoid AVE positive. That is in page 83, first paragraph, fourth line from bottom, my lord. That is in first paragraph, that the petitioner was suffering from Salmonella paratyphoid AV.
This has come for admission.
My lord, after notice.
After notice.
They have already
Who
appeared.
appears for the OPs?
My lord senior is appearing too.
If it is a willful absenteeism, that's a misconduct. But in life, which P.B. Shelley said in one poem, I fall on the thorns of life, I bleed. Such things happen. Admittedly, person was suffering from illness. And how long it continued?
147 days.
147 days.
Thereafter, I have
He extended 30 days. After his application, it was considered again 30 days has been given. Still then not joined in the place.
No,
Thereafter, the action has been taken.
He was there, and it is arising out of an in course of duty that you allowed him to go on leave. And he overstayed. It is a question of overstay.
Overstay.
Yes,
Not
correct.
unauthorized.
Where is the unauthorized absenteeism? A defense employee.
My lord,
Yes, CRPF employee.
CRPF constable.
Because of posting in that area.
Yes.
Then where is the justice element?
But here is the case, person has been suffering and thereafter he has submitted the application to the authority and authority considered the same extend 30 days time. Till then he is not turned up.
But
So
correct,
it is
but
distributed
bacteria
also.
and virus are not under our command.
It's true, but the substancing the document he should
What are the
substantiate.
documents he has given?
Yes, there is no such document except few private prescriptions. Let me say they have also annexed in document. Let me see.
Madam, what documents you have
Yes,
given
my lord.
to justify
My lord,
you are
yes.
staying away from the duty?
Yes, my lord. Page 56. That is every English translation is there. Page 56, paragraph 2. It is not that document, my lord. It is why I have chosen to be at hospital in.
What is this?
My lord, this is, they have stated, my lord,
Who have stated?
this is appellate authority. There, DIGP Agartala, who is my disciplinary authority there. My lord, kindly see. The process of deed then continued and the statement of prosecution witnesses were recorded in his presence by the EO. He offered to cross-examine each PW and inspect the materials exhibits on the records of D. He had chosen not to cross-examine the PWs. However, he has handed over copies of statements and other records of prosecution side to enable him to present defense and to uphold the principles of natural justice. He was afforded 15 days time by the EO to present the defense DW's exhibits during the course of D from 14 to 2009 to 28 to 2009.
Go to that particular rule.
In defense charging, he underwent treatment of alleged illness in private.
In some other hospital, but not the hospital of the department. That is what they are
choice. That is the allegation.
That's what we are asking. Which rule says that he should undergo treatment only in that hospital? Because we are told from the days of childhood, it is faith that heals, not the medicine. Unless I have faith in the doctor, what medicine is going to happen? Going to do?
That's true.
No, which rule prohibits? He is going to a private hospital of his choice. Maybe that he may not be entitled to allowance, etc. That is one thing. But how can you prevent a person from going to a doctor of his choice?
But there is we have a mechanism. The department has a mechanism. Suppose any of our employees suffering. CRPV is such a largest organization. Everywhere we have a regiment, we have a medical facility. Suppose in Assam, he can take a treatment for any place immediately. But thereafter he should take the advice from the concerned unit, he can take care of. Suppose sometimes he require airlift. We are doing so. We are for getting the emerging, controlling the emerging situation.
Which is the rule which says, this is the argument, which is the rule which says the employee of CRPF has to go not to the hospital of his choice for treatment of the ailment, but to the hospitals of the department only. Where is your rule?
Well, let's give some time.
Tomorrow?
Tomorrow.
That's the only point.
Yes, sir.
That's the only point. Tomorrow? Tomorrow, at the request of the DST.
Can it be day after tomorrow?
Yeah. At the request of the DST, who would place on record a copy of the rule book, which interdicts.
Lordship may say the rule book or the circular?
Rule book or rule positions, you can say, rule position, stroke circulars, which prevents an employee of the CRPF from going to hospital of his choice for treatment of the ailment. Item 30. How many years of service he has put in?
My lord, he is a young man, 5-6 years. He only at the entry age is only 35 years when he was removed from the service. He's a young man. When he was on leave, my lord. No, when he was on leave. When he was on leave, had been treated at the district hospital of Bulandshahr because he had no money to go to Delhi group center and with comfort food because they are all roti people.
How many kilometers from Assam to
Bulandshahr, UP to Delhi? My lord, must be Eastern Ghat, UP, that must be 400 and 500 kilometers. And he needs somebody for his attendance.
But that's not your case. You are building it now.
No, that I'm taking. Because of the lordship can understand it within this, that's why I have not stated.
Item 30.
May I please? This matter relates to regulation of the petitioners and the claim of the petitioners for regulation, even though they are continuing since the last 32 years. Against sanction post was rejected by the Central Administrative Tribunal, Cuttack Bench. I against the order of the Central Administrative Tribunal, Cuttack Bench, I filed the writ petition.
Take notice.
Now already notice has been issued, my lord.
Issued.
My lord. And your lordship's last order, this coordinate bench has passed.
I am similar. I am for the respondent number 2 to 4 appearing in the case, my lord. But the case with the complaint, my lord, the applicant that they were never appointed in any sanction post. They are clearly, and the terms kind of see Annex 1 of the report. But kind of see the Annex 1 page, my lord, 25 and 28th of August 1993.
Since 1993, they are working.
1993, because the interim order was passed by this Honorable Court, the writ petition, that 2 posts shall be kept vacant. And thereafter, Millard, they have filed an application, transfer application. Then the matter was sent to Millard, the London Administrative Tribunal. And the London Administrative Tribunal, after hearing the parties based on pleadings, initially passed an order. Millard, kindly see Annex 15, that is page 104.
You want us to turn the pages of the petition, we will do. It's our duty, we will turn the pages is one thing. But you need to answer the court's question.
Yes, yes.
We are asking you, how long they have been in service?
But they are in service.
How long?
But how about 29 years. Interim order was passed. Kindly see, initially the London Tribunal allowed their prayer. I may permit to place 2 lines. Regarding the other prayer of eligibility for the post of junior accountant as per the subsequent notification Annex 10 of the TA of filing of the junior accountants, the applicants are eligible for casual employees, which shows that there is
nothing in this rule circular for recruitment of the post of junior accountant to make the applicant eligible. The respondents have not furnished any rules or guidelines relating to recruitment for the poster. Hence, the respondents are directed to consider the filling of the 2 posts of junior accountant in addition to the pay of the vacant post, junior to while filling through promotion departmental selection by issue of appropriate notification as per the. And they were not granted some relief. Then they challenged the review application. The order was reviewed. Then finally, the order was passed on 25th of July 2024 at Annexure 16, page 109. There, the learning tribunal was considered the petitions and also observed that it is clearly based on record that applicants were never appointed against any sanctioned post through the valid process of selection as per the rules, and their blood case was considered for one-time exercise, and that was not been fulfilled. And also, can you see page 115, para 4? I just want to put three aspects.
Brother, are you from Delhi?
Where are you right now?
No.
It seems you
I
are
am Bhubaneswar. I have come to attend the court to Bhubaneswar. You let me keep it to next week. I'll come. I'll physically.
No keeping. We are not here to hear the matters in on installment basis. We'll never
I'll
give.
come next week. You let me keep it to next week.
Nothing like that. You have argued the matter. It's over now. We are not here to do
As you let I am assisting the honorable court.
They are paid heavily by the government. Judges are paid very heavily.
May I place some
29 years they have worked.
32 years.
32 years. That was from 1993
to till date, and they have sanctioned revised spell 56th because of English sanction post. Because of pendency of this case, 7th pay has not been extended.
Now,
and initially, my case was my lord
for regularization of services.
Regulation and completion of 10 years as per ML Keswari judgment, my lord.
Why ML Keswari? Lawyers travel to Jago.
Thereafter, my lord, recent judgment is, my lord, that is recent judgment, Dharma Singh. Relied on Jago also relied, my lord, Honorable Supreme Court.
Petition allowed in terms of Jago and Dharam Singh. Things they have worked uninterruptedly with effect from 1993. First, we are also told that they have been paid
5th and 6th pay.
5th and 6th pay commission benefits. Come on. Benefit of 7th pay not having been given.
Because of pendency of case.
Because of pendency of case. The reasoning of the tribunal is weird, to say the least, and therefore unsustainable. Regularization to be done within a period of 3 months. And report of complaint should be filed with the Registrar General of this court within 1 week following this, failing which the respondents are liable to be held up for contempt action.
Regulation,
kind permission. My objection,
yes.
My contention also merely because temporary casual worker has been engaged for a continuous period. And also I have cited 2-3 judgments. Kindly see page 116. I will reflect my objection and my contention.
After the completion of 10 years missions,
My lord, I am appearing for opposite party number 1 in this case. Union of
I have a prayer, my lord.
Yes.
I have a prayer, my lord.
Yes.
Because of my throat infection. Item number 30.
You appear to have eaten more ghee yesterday.
Yesterday?
Yeah. Or the day before.
I was ill yesterday. I was ill for the last 4 to 5 days.
No. You did not catch the hammer. We say here, you ate more ghee
yesterday
or a day before.
When
do you want?
32 items both are opposite to each other.
When do you want?
Next week.
Week after next at the request of arguing counsels on health ground.
May I submit, my lord? In this case, contempt is staring at us. So contempt has given it. There is an observation.
But don't precipitate the contempt.
My lord, this specific order, because arising out of a common order, two successive writ appeal have been filed. One by the Valmi authority, another is by the state. This order, can have a glance to the order in contempt.
Parties shall not precipitate the pending contempt proceedings.
Well, my lord, the date has been fixed to 30th. Any date my lord shall fix prior to that, so that matter
After
can
2
be
years
decided.
it will come.
Well,
You
this
can't
is-
harass the contempt proceeding.
My lord, they have not disclosed by the 6th. Any date my lord in between 30th 2 weeks.
I have a small request.
Nothing like that. There is no, we are not launching any satellite.
Yes. Item 31. Not appearance may be deleted because they want that they engage private counsel do it by the Red Cross. To Union of India may not be appeared, my appearance may be deleted.
In which?
Opposite one. Item 31.
31 is the name of the DST to be deleted. Since the
Department, Indian Red Cross will engage their own counsel.
the Red Cross has engaged its own counsel.
May I pray, my lord?
Yeah.
In this case, in compliance to my lord, I have sought copy on Mr. DSG, my lord.
Which matter?
In 31, my lord.
31.
So then your lordship may issue notice to OP number 2 to 4 so that they can engage their counsel, my lord.
You appear for whom?
I am for the petitioner, my lord.
You are for petitioner.
My lord.
Issue emergent notice to OP, respond number, OP number?
2, 3 and 4, my lord.
2, 3 and all right. Yes.
Item number 34, pardon to make a mention. Item 4. I appear on behalf of OP3. I will be seeking a short adjournment 2 weeks to file my counter.
What counter? It's an appeal.
My lord, I'll seek instructions, and if there is any instructions, we'll file
Your first contention falsifies the second contention. Second contention falsifies the first.
Because I'll also file my wakalatnama also. I also.
Then both the contentions are falsified with your third contention. All inconsistent contention. All right. The request of. You inform the other side.
Yes, sir.
You are there.
Yes.
Yes, Mr.
I will respond number 1.
In 31, 34.
34.
Those affidavit copy.
You are served on that.
They gave it now, but this is not the affidavit which is written in the noting. It is dated of 17/12/2025.
You give one Xerox copy of that affidavit from the file.
And there they have stated analysis that my party has taken some amount and her party
Let
has
us,
taken.
let us. You collect that
Obliged.
copy from us.
Obliged.
From our thing. Okay? After the court hours. But somebody can do it. Otherwise, madam has to wait. Unless it's.
I have a matter in another court. So I have a matter.
My lord may keep this matter on 22nd. In the meanwhile, we will take all those documents from
27th we have.
Let the matter be on 27th. Let me get the copy of the affidavit.
You will get it today.
Fuller reminder I'm not able to get.
Xerox, whichever madam wants.
my
last.
Item 26.
Yes, my lord. Well, on the last occasion, my learned counsel had shown one judgment with the unjust enrichment with regard to Rule 9(5) of security interest rules.
Yeah.
My lord, I need candid submission. My
You
lord.
have heard that. It's covered by judgment of the
My lord, I need 1 week time to just to come with some other judgments. My lord. Yes, please.
Choose.
Yes,
Find it.
grateful.
Find reluctantly. Yes.
Item 33.
Request.
May I please, Your Lord. But here, my lord, the appellant is the, my lord, bank with your lordship. My lord, what happened, my lord, the husband of the writ petitioner, my lord, was working as a forest peon in the bank, my lord. And he supervised forest peon, class 4, my lord.
Forest peon.
And my lord, he was superannuated on 30th April 2014, my lord. And after, my lord, 2 years, my lord, he filed a writ petition, and that writ petition was disposed of at the stage of admission by the order dated 20th January 2016, with the direction that to consider his representation.
Representation for?
My lord, for his terminal benefit. And the bank considered his, my lord, grievance, and the bank, my lord, disbursed 17 lakhs some odd in favor of the, my lord, deceased employee. Thereafter, my lord, the wife of the, my lord, deceased employee, who is the writ petitioner, my lord, widow, my lord, he filed the writ petition, second writ petition, with a prayer that my husband was something else to pay, my lord, get from the bank, and she filed, my lord. And in that,
some more money,
my lord. And in the writ petition, my lord, the honorable single judge directed the bank, so also the, my lord, writ petitioner, to sit together and my lord, amicably settle the matter, whether anything needs to be paid. Thereafter, my lord, the bank paid, my lord, 1 lakh some odd. And my lord, the writ petitioner filed the additional affidavit that she has to get, my lord, 2 lakh some odd. And the bank, my lord, also filed the reply to the further affidavit. But the honorable single judge filed, my lord, in the impugned order, those two affidavits, affidavit and reply affidavit, was not taken into consideration and directed to pay lump sum rupees of 5 lakhs.
5 lakhs.
Yes. May I kindly
what is wrong with that?
My response submission is that.
How much you would have got if the affidavits were considered?
Yes, ma'am.
If the learned judge had adverted to the affidavit and counter affidavit,
yes,
how much money you would have got?
My lord, what happened, my lord?
We are asking a question.
Yes, yes, ma'am. That regarding the honorable single judge said that regarding, my lord, PF amount 2 lakhs amount and the interest towards gratuity, my lord, 25 lakh.
Are you avoiding your question?
No, my lord. Sorry, my lord.
Weird.
No. Sorry.
Then you have to answer.
My lord,
how much money you would have secured?
Yes.
If the order was passed after looking into the affidavits?
Yes. 2 lakh, my lord, that is, my lord, 2 lakh.
Learned judge has ordered more than that.
Yes, ma'am.
That's your grievance now.
Yes.
You are for the bank.
Yeah. My lord, in fact, my 2,44,320.
2,44,000?
320.
So 5 is ordered.
5 is ordered.
So 5 ordered. Well, because delay, so many things have happened. You have made him to hover in the court corridor endlessly.
My lord, on 2 counts, my lord, the amount has been, my lord, set out by the writ petitioner. That regarding PF amount, but the fact remains that PF account was not opened at all during the service period of the, my lord, deceased employee. And the writ petition was filed, the writ petition thereafter, my lord, disposed of.
This 2,44,320.
Yes.
When you were supposed to pay him?
That, my lord, that was filed on 4/9/2024.
We are asking you.
Yes.
When you were supposed to pay, when the employee, 30/4/2014, he retired from service.
Yes.
This amount is paid when you had paid. You are not paid 2,44,000.
No,
You have paid less than that money.
Well, interest has been paid. All the towards gratuity payment, my lord, all the interest has been paid. Only interest part was remained, my lord, 24,807. By the date this affidavit was filed, my lord, that towards interest on the gratuity. My lord, when the affidavit was filed, only the interest towards gratuity was 24,807.
According to you.
Yes.
And
according to him, my lord. That is
what is that amount according to your affidavit? What is the amount payable?
6 lakhs amount. 6 lakhs exact amount. I'm telling you that is we have to get, that lady has to get on behalf of her husband provident fund contribution 5,37,000 to 2864.
Whether the husband of the deceased husband, had he contributed to the fund?
The fact is,
we are asking you a question.
He has not been
contributed at all.
No.
Then how can he seek the fund?
No. Why it? That is a problem. Fact is, the employee joined Ecobank as peon in 1980.
1980?
12 September 1980 as peon.
1980?
Yes. That is retable page 14.
1980.
Thereafter, at that time, initial basic pay was 245 rupees. Plus TA and HRA as admissible.
Yes.
He retired, reached the period of superannuation
on 30 April 2014.
Correct. Not a single increment bank has paid him throughout his service. Number one.
But on that ground, this lump sum is fixed.
That lump sum, we have that I'm coming up. That's what is the exact amount what they have paid.
No increment is paid from the entry level to retirement.
Number two.
What increments you were entitled to under the rules?
Under the rules, I have submitted a big list that she has to get total amount of 12 lakhs somewhat. Bank has paid. That's a writ petition, I'm telling.
Is it true that no increment was paid to him?
I see the Honorable Single Judge has mentioned this in para 14.
Para 14 of the impugned order?
No, appeal.
Appeal? How you are in appeal you mentioned?
No, para appeal, Honorable Single Judge has...
His impugned order?
Yes, impugned order. What they have said, now even fact of the appeal, what they have made appeal, they have also said, para 14 of the appeal, page 14, para 5. The deceased employee was appointed in Ecobank as a Ghanteshwar branch as peon from Paras on 12th September 1980. Then para 6. He declared a deceased employee was appointed at initial basic pay 240 rupees per month plus whatever it made. Then page 15, para 7.
Plus DA. Where is the increment? Where is the pay scale?
It is 245 to up to 12,000 somewhat. That is as per the...
That is not movement.
That is the bipartite settlement takes place from every 3 years. Every 3 to 5 years.
Where is that rule?
I have... I have seen it.
Brother, whether you have given increments as and when they accrued annually?
Annually.
Where have you stated? You have paid this.
In fact, my lord.
One sentence in your
Yes.
question is, have you paid the increment?
My lord, since the increment was
Brother, where is your complaint that no increment is paid? Where have you stated in your petition?
That we have given a representation. And
where is that?
That is why lump sum of rupees 70 lakh was paid. As per his calculation, he has to, my lord, he said that only I will
show that you have raised a grievance as to non-payment of the incremental wage.
That is a writ petition.
Show that.
9067 of 2016.
All right,
Show it.
Page 3. Writ petition, page 3. Page 4 to paragraph 4. Then it is continuing page 3.
Petition, page 3.
Yes, writ petition. Writ petition.
Which one? WPC 9067.
My lord.
That is page 12.
12.
Page, internal page. Internal page 3.
Page 3. That is.
No, you have shown it to be difference amount.
No, that is there. What we have calculated, that is the amount due from gratuity and for delayed period of interest.
Thereafter, you have not claimed for the increment.
Increment, they have, including increment, they have calculated.
Have you claimed from your side?
The bank has paid it. Bank, after realizing that their mistake, they have paid it.
Paid it when?
Paid it in 2017, I think.
After the disposal of the writ petition, the bank has paid 17 lakhs.
All right, but what does it include? What does it include? It is the including the increment.
You will also kindly have a glance to page 20, my lord, paragraph 8. Running page, my lord. There, my lord, the bank has given the detailed calculation.
Simple thing we are asking. We are asking where the 4 goats are. You are saying the evolutionary history of the goats. We don't want that. We are asking you whether he raised any grievance as to non-payment of the increment. You admit that he had.
Yes.
Because you have paid, according to you, you have paid it.
Yes.
For how long it was not paid?
Well, that was not paid.
In the entire career of his service.
Yes. Whole service.
Why don't you say that?
Yes, my lord.
You say that. Be clear.
And
my lord, that is.
My lord wanted to know what are the bipartite settlement as he entitled for this. This I have already submitted before the Hon'Ble Court, single bench, and this is also copy I am having. Throughout year-wise I have calculated what should be due.
That money is not given to you.
That not given. That is they have.
In the lump sum amount which was paid to you. That did not include an increment.
Yes, it includes increment.
That includes increment.
Yes, increment. I have shown that these are the dues I have claimed, and a bank has gone through it. Thereafter, they prepared the computed sheet is there, what says that he is to get amount of 17 lakhs amount they have paid. Out of that,
according to you, how much amount should have come to your hands?
6 lakhs amount. 6 lakhs exactly 6 lakhs amount. But court has considered.
Let's kindly see page 29, page 28 and 29, annex 4, my lord. That will be clear, my lord. That is the further affidavit after receiving all these amounts, my lord. 17 lakhs and thereafter 1 lakh somewhat. Page 28.
Totally how much you have paid?
Totally 17 lakhs and thereafter during pendency of the writ petition 1 lakh somewhat, my lord.
18 lakh plus 1 lakh.
My lord, 18 lakhs somewhat.
18 plus you have paid.
Yes, my lord.
1 lakh for interest.
And please. And you also can have a glance to page 28, my lord. Page 28 of the appeal, my lord. Only page. That is the further affidavit filed by the my lord petitioner. And kindly have a glance to page 29.
This calculation sheet is prepared by whom?
By the writ petitioner.
And according to him, how much he is entitled to?
My lord, yes, according to annexure, my lord, paragraph 3, my lord, according to annexure 5, page 16 of the writ petition, the bank has to pay bank's contribution to provident fund 2,18,674, net amount payable 2,18,674 plus 25,646, total amount 2,44,320. My responsible submission is that, except that my lord, interest toward gratuity, the PF amount he is claiming that has not been my lord his contribution. Rather, if the PF account was opened, then the bank has to pay. This is the amount 2 lakhs amount. Total the
who should have opened the PF account? You, employer.
Yes.
You did not open. Why he should suffer?
What happened, my lord? due to irregular in service, the PF account was not opened. And that was also not his challenge before this honorable court. In the first writ petition, so also the second writ petition filed by the writ petitioner.
All right. He has worked from 12/9/1980 to 34/2014.
Irregularity in the sense, once the establishment is covered under the PF, even if he works for a day, he is included.
If he works for 180 days, he is entitled to it.
So you being the employer, it was your responsibility.
Your responsibility. You don't find any error in this.
Yes, but if it is allowed, if
the banking intercourt appeal for laying a challenge to the Lafayette single judge's order, which inter alia directed payment of ₹5 lakh in a lump sum towards the discharge of liability owed to the employee. First, learned counsel for the appellant bank vehemently argues that a writ court cannot award a lump sum like a Mughal when calculation sheet as part of affidavits was filed, and therefore the public money cannot be spent on disentitled factors, heads. First one, he submits that the employee himself has mentioned that a provident fund of ₹2,18,674 was to be paid, there being no opening of provident fund account. First one. Further, he submits that even according to the employee, net amount payable was ₹2,44,320, and therefore lump sum awarded by the learned single judge is alterable. First one. Next one. Learned counsel appearing for the widow of the deceased employee opposes the appeal, making submission in justification of the impugned order at the regions on which it has been constructed. First up, he points out that the employee in question was in service during the period between 12/9/1980 and 30/4/2014, when he retired on attaining the superannuation. First up, the learned single judge, having worked out all the equities, has awarded the lump sum, which does not call for interference of this court. Next one, having heard learned counsel for the party and having the appeal papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the learned judge. First, according to the counsel appearing for the bank, appellate bank commands, what is payable to the employee was only 2,44,320. First, however, a sum of ₹2,18,674, which was otherwise payable by way of employer's contribution to PF under the extant rules in question, has not been accounted for by the appellant. First up, why a PF account was not opened is also not specifically mentioned, except saying that the employee's service was irregular. First one, that contention does not merit acceptance, since it is the incumbent on the employer to make a contribution to the statutory provident fund. First one. Next one. Even otherwise, we do not find that the impugned order has find any infirmity in the impugned order which has brought about a just result to the widow of a low-class employee, that is fuel, who had served for long with the spotless service record. First one. The writ courts also exercise a kind of equity jurisdiction and settle the competing equities in particular fashion. First one, unless that is shown to be contrary to law and justice of the case, an intra-court of the appeal, intra-court appeal of the kind is not maintainable. First, in the above circumstances, the appeal being devoid of merits is liable to be rejected, and accordingly it is with a cost of ₹5,000 payable to the respondent within a period of 30 days. First one, if delay is done, so the rest of the money is paid now. Whatever amount is paid now.
Yes.
That amount is paid. 5 lakh is paid. First one.
No, not 5 lakh. These 5 lakhs.
The order of the internet single is to be implemented within a period of 60 days. 60 days. Oh. Yes, next.
Item 35.
Yes.
President Appeal Miller, the appellants are the slum dwellers, Miller. They have been staying over the land in Hussain for last 3 decades, more than 3 decades, Miller.
On what title?
Miller?
On what title? On what right?
Miller,
property is not yours.
No, Miller. But under the Slum Dwellers Act, we are protected under the Slum Dwellers Act 2017. This is. And the authorities concerned have already issued the certificate in our favor under this Act, Miller.
Where is that certificate?
Under Annex 3 series to my appeal.
So the certificate is issued under which section? Why you give only one set?
Sorry.
No, that will be good also. I can write the certificate.
No. And Miller, what happened when the present
you
appearance?
are not party to the proceedings of the learned single judge.
Honorable single judge. And the honorable
you file review under section under the 64 Supreme Court. Shivdev Singh versus so and so. AR 1964. Take out that judgment. Why intra-court appeal?
Miller.
He will be knowing everything.
Miller.
Learned single judge will be knowing everything.
Yes, ma'am.
Shivdev Singh says, Constitution bench says, where an order is made adverse to the interest of a person who was not a party, you nominate to the original proceeding, he can prefer a review by filing a writ petition.
Yes, ma'am.
File that.
But why with the present appellants came before this honorable court?
You have not seen that judgment at all.
I will go through it. But why I filed the present?
You are going through it to argue.
No. I don't want to argue. Only, yes, sir. Your Lordship, may kindly take up this.
Shivdev, S-H-E-O, Shiv, S-H-E-O, Shivdev, that way it was. Singh versus so and so. Shivdev, S-H-I-D-E-O, Shivdev Singh versus State of Punjab. You want to look into it and come back, or you want to argue and the case?
I want to go through it.
Call week of next week to enable counsel for the petitioner to come with more preparation. Yes. Item 36.
Item 36.
36, my lord. We have received the notice. And I have appeared on behalf of the respondent number 2. And I have not received Bhokladna so far as from 1 and 3 is concerned. Lordship, make some time to file our Bhokladna. We have received the notice, but
You appear for the OPs?
Yes.
We'll record that.
My lord. I am for the appellate, my lord. Lord, it's a simple case, unnecessarily made complicated. Now, without opening the file, my lord, let me explain. Arbitration award under the National Highways Act, having attained finality.
353.
Yes.
Yes.
Having attained finality, 34 application rejected, then no 37 preferred, writ application preferred against 34. That was also dismissed. Appeal attained finality.
So award has attained finality.
Award has attained finality.
Yeah.
Award put to execution.
Yeah.
When the award is put to execution, well, the National Highway Authority, and there was an order by the executing court to the Land Acquisition Officer of the National Highway, that is in short CALA, Competent Authority, Land Acquisition. Direction was given to him to deposit the amount. And what was the amount? When there was a direction to deposit the amount, then he rushed to this Hon'Ble Court, files a writ application by saying,
which application?
By filing a writ application, by saying that the arbitrator was to arbitrate with regard to National Highway 6, but there has been a wrong nomenclature. This is National Highway 215. That was entertained by, allowed by this Hon'Ble Court, that the right approach ought to have been to move an application to move under Section 33.
33 provides for it. It is on par with 152 of CPC.
Yes. So these things could have been done, Malad, under Section 33. Then, Malad, the petitioner challenges this order before the Honorable Supreme Court. Honorable Supreme Court sets aside the judgment of this Honorable Court, restores the order passed by the Malad Executing Court.
What the Executing Court had said?
Had directed Malad CALA to deposit the amount.
Yeah.
Then, Malad, during that time, Malad, a suit was filed by the present respondents 1, 2, and 3 for partition with regard to the property. I'll just give Malad the narration of details, dates, Malad, but now for the timing, Malad, let me tell you the bird's eye view picture of the entire case, Malad.
You are the beneficiary. Petition.
Yes. And the suit was allowed to be withdrawn before the Lok Adalat. And when the application for withdrawal specifically mentions by the respondents 1, 2, and 3 that they won't prefer any other
it was unconditional
withdrawal.
Coupled with the condition that they will not prefer any other.
Yes. and it was before the Lok Adalat. Then subsequently, National Highway Authority moves another the project director claiming to represent National Highway Authority, files again a petition before the Executing Court that the project director ought to be implicated as a party before the Executing Court. The Executing Court rejects that application. On rejection of that application, the project director comes before this Honorable Court, filing a CMA. That CMP. That CMP was also rejected, dismissed. Again, the dismissing of that CMP, Malad, National Highway, the project director goes to Supreme Court. SLP dismissed. And Malad, again, the impediment application rejected, Malad, by project director. And in the meanwhile, the project director files a suit to declare Malad
or to be null and void.
Null and void. And he files a suit by saying that he is the person to represent National Highway. It is not the CALA. And we filed an application of order 7.
Such a contention was taken when he challenged the rejection order of the Executing Court.
In CMP.
No. But we had placed those things, Malad. Please don't interfere. I'll show the record.
We'll hear this. We'll give full opportunity.
We'll show the
Receive the notice without the.
well, now this shows the nexus.
You want papers?
Paper book, madam.
Okay, give paper book, we'll have it day after tomorrow.
Yeah, well,
But we may levy heavy costs on you.
Yes.
We are putting it to you. Come with preparation. So that we are putting to you that we are likely to levy heavy costs in the event of what the senior advocate said is verbatim true.
And
is verbatim.
And then, my lord, but 3-4, just please, wait. Then, my lord, then the respondents 1, 2, and 3, after withdrawal of the suit, my lord, they file an application under Order 21, Rule 97.
97.
Obstruct or supplication. Yes. And making a prayer therein that the award be set aside.
How 21?
Yes. That was the application, and that application having been rejected by the Malad Executing Court, against which appeal lies, Malad, under the
under 103.
Exactly, Malad.
Yes. Rule 103.
Yes. Then they challenge by filing a Malad's filing.
It's deemed to be a decree.
Yes. By filing a CMP. Well, so that is why, Malad, I fully agree with great respect to my Lord Justice what fell down with regard to cost.
You can name the justice also. Why lawyers do not name in your state the name of the judges? I do not.
Honorable Justice.
Partners in the legal process.
Blood, may I add to just break the monotony, we are not partners of a crime, we are partners.
I did not say it. I will go one step further. The sharers of the booty.
Exactly.
We are not.
Exactly. Then what happens? Well,
so you give a full set of paper.
I will.
So that he also let him look.
Well, only 3-4 sentences.
Yes.
I'll close.
Yes.
Prima facie felon.
Yes.
Then CMP was allowed to be dismissed for non removal of the defect under 227. Then a 226 application was filed.
After that,
in the 226 application, well, the order passed by the executing court rejecting Order 21 Rule 97 was entertained, and I will take a lordship to the entire order. The order absolutely takes away the legal proposition, and the order holds that the writ petition is maintainable in view of AIR 1999 Supreme Court page 22. Whirlpool.
No. Whirlpool only said alternative remedy is not a box in a given set of circumstances.
And the judge, this is what the learned single judge has held. And again, Section 22 of the Orissa Land Reforms Act is out of question, because initially the original landowners, they had sold to somebody who is also scheduled caste. That scheduled caste had taken permission to sell the land to me, and I bought it by only taking permission. And Naled Single Judge, what he did, Balad, in a Order 21 Rule 97 application, sets aside all the settlements. After the award has attained finality, Malad, he sets aside all the Malada settlements.
You set of paper.
I am giving
you have an uphill task going by what your friend has said now.
Malad, each of the submissions is backed up by Supreme Court judgments. Every sentence I uttered is backed up by Supreme Court judgments.
Appears to be so.
Yes.
Because 1976 amendment to CPC,
yes.
Rule 103 is added.
Yes.
103 deems an order passed under Order 21, Rule 97, a decree.
A decree.
So if that is a decree, regular course of appellate remedy should have been sought for.
Yes.
One judgment, I don't remember.
But the latest Supreme Court I had with me, I have it.
There is one judgment.
But there are incidentally in 2024-25, there are judgments which take care of all my submissions. And an honorable judge was not having the assignment to hear 227.
Treated the subject.
And he hears 226. Takes it up. It's a nullity.
We'll look into.
Yes, sir.
Hey.
I'll serve by day after.
I am for the respondent number 6.
National Highway Authority.
In a second.
All this is generated because of your act only.
Yes.
I am satisfied, Lordship, my lord. I always agree. Whenever I am appearing before my lord, I always agree with your view. My lord, I hope and trust that my lord will hear the matter in full extent. If my lord find out that I am the rightful person, whatever I leading this discussion to my lords, whatever my lord will pass, I will accept that.
You will hear this next thing?
Yes, sir. Yes.
Whether 28 is ideal thing to all of you.
Well, 28?
Or any date of your.
Man, I have no issues with that. Yes.
Or this matter on 20th of this month. Give the copies.
I will.
Will not make any order in that.
But there's an interim order passed that has to be.
Interim order to continue. Interim order to continue.
Item 37.
That judgment I just record. Paramount Industries versus so and so. ILR 1991 Karnataka. It's going to be affirmed by the Supreme. Paramount Industry. Can you take out that judgment? Yeah. Take out that judgment.
I'll be grateful if at all
there is.
She passes on to me.
Yeah.
And Lordship knows that Rahul Roy case filed. Rahul Shah case filed.
I was the author of the judgment.
Yes.
Went to Supreme Court and
yes.
1 year for execution.
Yes, 6 months.
Now 6 months.
Yes.
Subsequent judgment. Yes. The other day, your friend, some young lawyer cited that. Rahul Shah said 1 year.
Rahul Shah said. Rahul Shah mean my lord, justice rendered by Justice Rahman.
Correct. Correct. Paramount Industries versus CM Malliga. You don't have ILR. Okay, what is this?
Yes,
the ILR 1991 Karnataka 254.
I got it.
Item 37.
The last occasion, the Lordship directed me to file the date chart for which the matter was awaited. And I have prepared the date chart with
share a copy.
Yes, ma'am.
With your 2016.
With the case numbers with reference to the rate appeal.
You are for respondent?
I'm for the respondent number one. Single respondent
for the state appellant.
Don't have any ill will as to what happens in the court other day. We don't remember. We say because you should not have hesitation to argue the matter. You argued so well. I told it to my colleagues also. He tried his because he has to protect the interest of his client. Client will be saying him. Yeah.
I have prepared.
Can I place that date check?
Once, what brother?
I am for the appellant. So I have prepared a short date chart. Lordship, I will place that.
Yes.
4/4/2012, the father of respondent number 1, late Niranjan Panda, while working as a driver in the office of RTO Patak, was died in harness.
Was you can remove. Died in harness.
Yes. So 1/8/2012, the respondent number 1 has applied for compassionate appointment under the RA scheme, as his mother being medically unfit for any active work, and 3 sisters were married in the meantime.
Yes.
So 10/8/2012, the application of the respondent number 1 was forwarded by the regional transport officer to the transport commissioner for consideration. 1/3/2013, the transport commissioner has sought for permission and approval of the government for compassionate appointment of the respondent number 1 under RA scheme.
Is it a legal requirement?
Yes, it is.
The law says like that.
Yes.
Can you just halt and show that rule?
But that rule, your lordship may find at page.
Which rule says the government's approval is required?
But your lordship may find at page.
No, you show it from your rule to sustain this stand. Because Transport Commissioner is a high-ranking official.
But that's right. Any appointment made under the rules or not any rules. So approval of the government is necessary.
Show that.
Not.
Which rule?
But that was not under the RA rules.
Yeah. We have held RA rules are exhaustive. We have held that way.
Page 42, Annexure 8. Page 42 is the RA rules.
RA rules we are holding in our hands now.
Well.
Which rule says on this? Just take assistance of your colleague and you can proceed with the argument.
That condition is not there in this. It's not there. I am very practical. But in normal circumstances, the Transport Commissioner, where the Transport Commissioner is appointing authority, and any appointment made by the Transport Commissioner is subject to approval of the government.
That is what you are arguing.
Yes.
That is, he horse the rules. Yes. When you have made the rule, rest of the things will fall apart.
But in all recruitment rules,
no, I do not.
Unless you were telling about the practice, probably.
We have not on
But in all, Millard, in the recruitment rules, there is the provision for approval.
Show that. Straightway will agree. Provided compassionate appointment is also a regular recruitment.
But that rule is not there. Sorry, Millard.
All right, which other point?
So, may I place that?
You go to the next point now.
Yes, Millard. So, Millard, the
government
4/7/2013,
the medical certificate of the widow of the DC government. How the government does all these things? We are government by the law, not government above the law.
Yes. So, Millard, the government has sought for the certificate, medical certificate of the widow of the.
What is the basis?
That is not the basis as per the rules. Since the appointing authority is the Transport Commissioner. Lord, why this matter stood as thus? On 12/11/2013, the government of Odisha, in exercise of power conferred by proviso to Article 309 of the Constitution of India, and in supervision of the respective recruitment rules, orders, and instructions, so far as the matter relates to mode of appointment of the selected candidates to certain initial appointments to Group C and D post of the state has been framed, the Odisha Group C and D post contractual appointment rule.
How that will applicable to them?
Blood,
is the compassionate appointee.
Yes, Blood. So I will then, Lordship, kindly see the CA rules. That is page. Running page 42. Lordship already have that rules.
We have that.
So may I place certain provision of that CA rule?
These are contractual appointment.
Yes, ma'am.
Whether compassionate appointment, contractual appointment.
No, Lord, all the post under the government in category C and D is treated as a contractual.
No, question, do you treat the compassionate appointment also contractual?
Yes, my lord, that is.
Show that.
Yes, your lordship kindly see that rule.
That was there in 2013 after. They will be
After
appointed
2013.
After 2013.
Yes.
The case does not belong to that particular era at all.
Lordship kindly see this here rule. That is, yes. I will place, my lord, 4 provisions under that rules.
But 2013 rule has already been abolished in 2021.
That is there. That has been repealed. Lord, rule 4. The rehabilitation assistance is received as a compassionate measure. That is the RA rule.
Conceived.
Yes. Conceived as a compassionate measure of saving the family of the government servant from immediate distress when the government servant suddenly dies while in service. The concept is based on the premises that in case the sudden death, his family would not face starvation. The scheme has a direct relationship with the economic condition of the family of the government servant. Appointment of the family member of the government servant under these rules shall be subject to provisions contained in Rule 9 and cannot be claimed as a matter of right. That is, Your Lordship, I will later come to the Rule 9. Then, my Lord,
this is what rule?
that is, my Lord, rehabilitation assistant rules. That is the scheme. Yes, that is the scheme. So, Lord, Rule 5. In deserving cases, a member of the family of the government servant who dies while in service may be appointed to any Group C or Group D post only by the appointing authority of that deceased government servant, provided he or she possesses the requisite qualification prescribed for the post in the relevant recruitment rules or instructions of the government without following the procedure prescribed for recruitment to the post, either by statutory rules or otherwise, irrespective of the fact that recruitment is made by notification of vacancies to the employment exchange or through recruitment examination under the relevant recruitment rule. Then, Your Lordship, kindly see Rule 7. The appointment under these rules shall be made once at any post, either Group C or D, which is a base post in the said groups, and the maximum scale of pay is prescribed at that time. Then, Your Lordship may find Rule 9. 9.1. So, appointment under these rules can be made only against the posts required to be filled up by direct recruitment and not against promotional. So, Group C and Group D post for a direct recruitment is relevant at the time, that is the CA rule, contractual appointment rules. I'll place that rule. Your Lordship may find page running page 66.
The post to which the only avenue of appointment is direct promotion post.
Yes.
To them, these rules are not.
Not. But direct recruitment to the Group C and D post is applicable for appointment. So that rules, Your Lordship kindly see that CA rules, contractual appointment rules, that is page 66. Running page 66. That preamble, Your Lordship may find.
To whom these rules apply?
Lord?
To whom these rules apply?
Lord, I'll show, Lord. The preamble, Lord. In exercise of powers.
That's all the proviso to Article 3.
Yes, Lord, that on that occasion, why I am saying, Lord, on that occasion, my friend submitted, that is not a rule, 309 rule. So, Lordship may find the definition, recruitment rules. Means the rules framed under the proviso to Article 309 of the Constitution of India, regulating recruitment to different state civil services and posts. Then, Your Lordship may find applicability. Rule 3. These rules shall apply to Group C and Group D posts which are filled up by way of direct recruitment. Then, O Lordship may find.
You mean to say the expression direct recruitment includes the compassionate appointment also?
Yes. What are the posts available, the vacancies available for direct recruitment, the post, the person claiming for compassionate appointment shall be allotted for that vacancy. So that is the rule, C rule. That is the rule. Then, O Lordship may find the recruitment procedure. Rule 5, may I place? The recruitment to the post shall be made on the basis of provisions of relevant recruitment rules or executive instructions as the case may be in post. Then, important, O Lordship may find, notwithstanding anything contained in relevant recruitment rules or executive instructions as the case may be in force, all appointments made pursuant to sub-rule 1 shall from the date of commencement of these rules be on contract basis. That 6 also important, O Lord. The status of vacant post for the purpose of contractual appointments made under sub-rule 2 of Rule 5. All vacancies existing on the date of commencement of these rules, as well as the future vacancies, shall be deemed to have been converted to contractual post from the date of commencement of these rules. So in view of these rules, the appointment has been made to the petitioner and the order of appointment, O Lordship may find at annexure.
No, I believe you. We have no reason to doubt you.
Yes, but that appointment letter, O Lordship may find 63, at page 63. Rakesh Panda, and the terms and conditions, O Lordship may find
2 and 5 are
2 and 5. After joining the service, the petitioner has filed the original application before the Learned Tribunal, challenging that condition 2 and 5. And that original application was transferred before this Honorable Court. And in the present impugned order, the Honorable Single Judge has clarified
that it was before the tribunal earlier.
It was filed before the
then transferred to abolition.
But prior to appointment, there are several litigation between the government and the petitioner, and ultimately appointment was made in the year 2018
on contractual basis.
Yes,
and with these conditions, amongst others, condition numbers 2 and 5.
Yes,
rest of the conditions, the appointee is happy. Brother Monty, he is happy with the rest of the conditions. What? Not happy.
With what he will be happy? He only can say on taking instruction from his client. But so far as I am concerned, I challenge those conditions of
2 and 5.
Yes.
All conditions.
If your lordship.
No, I am asking, we do not learn.
No. But why it is so?
No, why not necessary?
No, your lordship.
You had challenged only 2 conditions or all other conditions?
My lord,
only 2.
All conditions.
Only 2 conditions.
Only
my lord, there are certain the other
conditions.
The other conditions are interrelated. The other conditions are interrelated. Once I will accept that contractual appointment, the other conditions at serial number 3 and this 4, everything will come in play.
What was your prayer before the tribunal?
Well, before the tribunal, my prayer was the appointment made by applying this particular with these conditions is not acceptable because the other 2 circulars by which the applicability of OCS RA rules 1990 has been extended to be made under this group C and group D, that also I challenged. My lord, the friend misses that point. You lords may kindly see.
You may come to those points later. But he is counting these points.
I have not only challenged this, I have also challenged the executive instruction whereby instead of amending the provisions of OCS RA rules available at Rule 7, they have by way of an executive instruction, they wanted to extend the applicability of these Group C, Group D contractual rules
to those appointments under OCS RA rules. That has been deprecated by this honorable court in the other judgment, saying an executive instruction
Cannot alter
its efficacy cannot supersede a statutory recruitment rule. Since you have not amended the rule by virtue of the power available under the proviso to Article 309, by virtue of this clarification, you cannot get the applicability of the OCS RA rule extended for some other purpose by way of another rule.
Let us.
Then, our Lordship, his appointment is purely on the basis of that CA rule.
In other words,
that is
you
the,
say it is contractual.
Yes, that is the post under the government for direct recruitment against which the petitioner has been appointed as compassionate.
These rules which you are now reading,
yes,
do they mention anything about compassionate appointment?
But in that rule, because no, there is. But the rule 9
interpretative process, you say they refer to compassionate appointments also.
Yes, that is rule 9, one of the.
What the learned single judge said?
But what happened? The rule, contractual appointment rules has not been asserted before the honorable single judge.
What learned single judge said?
The clarification of Lordship may find at page 75 and 76 was under challenge before the honorable single judge.
Yeah. And single judge said?
Single judge has held that the clarification issued by the GH department is adheres the
rules,
statutory rules, and so that has been quashed, and the petitioner is directed to the present appellants are directed to regularize the service of the petitioner from the date of initial appointment, and all service and financial benefits be extended to him. So without
his son.
Right. So without touching the relevant provisions under the rehabilitation assistance rules and the relevant rules, recruitment rules, that is the contractual appointment rules, the honorable single judge has held. But the impugned order passed on 36/2023. That is, my lord, Annexure 2 at page 77. And prior to that, in a batch of writ petition, this honorable single judge has held that clarification adheres the rules, so it has been quashed, and the order passed in the present writ petition, the honorable single judge has held that the writ petition is disposed of in the light of that judgment. Lordship may kindly see the judgment, page 77.
This judgment is rendered in the light of another judgment.
Yes, that is
Biplava Kumar.
Yes, Lord, that is I have annexed at page 81, annexure 3.
That is rendered by whom? Another judge.
Same
judge.
Same.
This did you challenge?
This has not been challenged. Lord, this
is between the you are the party.
Lord, here state is a party, but here the department is Home Department, appointment of constable. So here we are the Department of Transport Department. Lord, that judgment, my instruction is that judgment till date has not been implemented.
Implemented or challenged? We have not
challenged or implemented, and nobody has filed the contempt.
We don't know.
Nobody has filed the contempt.
That's all. Whether they file contempt or not, judgment is judgment.
Well, that has not been challenged. So after passing of the impugned order, the present respondent number 1 has filed contempt application, which has been disposed on 19/12/2023. And this honorable court directed to comply the order within 1 month. So after producing that order, the department sought for clarification from the Home as well as the Law Department as to whether the judgment in Biplava Kumar Sahu has been complied with or any appeal has been preferred.
Yeah.
So that
in that clarification, the law department says that file is still before the department and no decision has been taken.
Well,
So in the meanwhile, the respondent number 1 filed the second contempt before this Honorable Court.
yeah.
So in the second contempt, the present appellant has filed a reply affidavit and compliance affidavit by stating that
We don't need it. That will look into all.
now, my lord, why I am submitting, my lord, only to show bona fide how the delays occurred in filing the appeal. Because earlier judgment passed by this Honorable Court, it is Home Department. Home Department has not filed appeal. Our Transport Department sought for clarification and contempt file. In contempt, there was a personal appearance.
This present appeal is filed with the delay or without delay?
It is a delay, my lord.
849 days.
840.
No order is passed on that application as that.
No order. This is the merit of the case and the delay is there. My submission is there is no negligence on the part of because of the bona fide belief that the order has been complied with in view of the repeal rules. But how the repeal rules came into force? But the repeal rules came into force in the year 2022. Not before passing of the judgment.
Repeal rules?
That contractual appointment rules has been repealed.
Repealing rules.
Repealing rules. So Lordship may kindly see.
Which rules they repealed?
Blood,
They repealed
the CA rules. Contractual appointment rule.
2013.
2013.
they came into force when?
Blood, they came into force on 16th October 2022. Blood, Lordship may find it at page...
Repealing rule.
Yes. Page 80.
2022. Prior to delivering of all these judgments in different cases.
No. CA rules 2013
That has come on 31st 12 2014.
came into force.
CA rule came into force on 13/11/2013.
No, if that chart is correct, you say that.
That is made effective from 18th November 2013.
Yes.
Page 66.
18th November 2013.
Rule 1, sub rule 2.
18/11/2013.
These rules are repealed on?
Repealed on 17th October 2022.
What are those rules?
That is, you may find at page 88, Annex 4 to the appeal.
1 second.
Page 88.
Page 88.
This is BCE repeal and special provisions rules.
Yes.
Repeal rules 2022.
Right. Lordship may find special provisions under Rule 4. Rule 4. The initial...
all that may not be necessary.
But in view of that Rule 4, Lordship may find the next page, page 90, all the service benefits and regularization has been granted on 18/3/2023.
All the means what?
His service has been regularized from the date of initial appointment. And as per the rules, the period already spent has been treated as notional, and from the date 17 notional. As per the rule.
That is
no, the rules say.
No, that's what provided what repeal rules are applicable to him.
Yes.
We do not subscribe to that view at all.
So since the appointment
now.
Yes, since the appointment was made under that rules, and that is the post.
It's your case. You have said that, and we'll take it.
Yes. So that fact was not before the single judge. So in the contempt application, we have filed the reply affidavit stating that before passing of the impugned judgment, the service of the petitioner has been regularized.
But with notional benefits.
With notional benefit as per rules.
But you have to give full benefits. If you give it, everything will be, problem will be solved. Otherwise, you are
Lordship may decide. But I will not argue the law. What are the facts I have submitted? Lordship may decide.
We decide. We are going to decide. No, we have the option to say we will not decide.
From this side, everyone gets relief. From this side, That side is defense. Now I'm appellant. Now I am appellant. So that is why I choose from this side today. So this is the so one of the objection raised in the objection, the respondent has stated that since the earlier judgment has not been challenged,
Because every department is a limb of the government.
Yes. Not one judgment of the
judgment. Supreme Court judgment.
So one of the
Praga Tools versus so and so.
Yes.
Or some other judgment.
Prayag Tools.
Praga, Pragu, something like that.
I have cited one of the judgment in my favor.
What it says?
2006-11 SEC 709, Colonel B.J. Akara and Government of India. That is paragraph 26 may read.
What it says?
I have submitted flag E or Lordship may find. Flag E. Paragraph 26. That dead chart and flag E.
What it says?
May read
Not reading.
The said
we have to read the entire judgment on what day I need it. That we cannot do. We have to ration the time.
No, only small paragraph. So the said observation applied to this case, a particular judgment of the High Court may not be challenged by the state where the financial repercussions are negligible or where the appeal is barred by limitation. It may also not be challenged due to negligence or oversight of the dealing officers or on account of wrong legal advice or on account of non-comprehension of the seriousness or magnitude of the issue involved. However, when similar matters subsequently crop up and the magnitude of the financial implications is realized, the state is not prevented or barred from challenging the subsequent decisions.
You pleaded those things. Have you pleaded that financial implications are heavy? Therefore, we are challenging this and we are not challenging that.
That is the sole intention.
Because we do not know what is lurking in your mind. Because we are not heart specialists.
We are in appeal.
You are in appeal on what? See, he has taken a playground.
Yes.
I think government has suffered an order which it did not challenge, and therefore that order having been followed in another case, that cannot be challenged. The easy version. Yes. Simple version. Textbook, administrative law textbook. Ground. If you bank upon this decision says, as you rightly say, that state can challenge the subsequent decision provided A, B, C, D, E, F, G factors are present. Have you said anything about those factors in your appeal memo? Not even one sentence whispered. This is not unconditional order. It says you can challenge, provided your case falls into these three circumstances, not otherwise.
In that principles of res judicata and legitimate fairness is not attracted. In latter part of of course, the position would be viewed differently if the petitioners plead and prove that the state had adopted a pick and choose method only to exclude petitioners on account of malafide or ulterior motives. Be that as it may, on the facts and circumstances, neither the principles of res judicata nor the principle of estoppel is attracted. The administrative law principles of legitimate expectation or fairness in action are also not attracted. Therefore, the fact that in some cases the validity of the circular is challenged, that is the so.
Please come to page 7, 112. Come to para 26 of the judgment. Our pages may not match with you. Judges and lawyers generally are not in the same page. Come to 26.
Paragraph 26.
25 also.
Yes.
25.
Yes,
So because it's Maharashtra versus
24,
Digambar.
25 and
25 and 20. Read.
so sometimes a similar contention was considered by this court in state of Maharashtra versus Digambar, and this court held sometimes, as it was stated on behalf of the state government may not choose to file appeals against certain judgments of the High Court rendered in writ petitions when they are considered as stray cases and not worthwhile invoking the discretionary jurisdiction of this court under Article 136 of the Constitution for seeking redressal therefore. At other times, it is also possible for the state not to file appeals before this court in some matters on account of improper advice or negligence or improper conduct of the officers concerned. It is further possible that even where SLPs are filed by the state against judgments of the High Court, such SLPs may not be entertained by this court in exercise of its discretionary jurisdiction under Article 136 of the Constitution, either because they are considered as individual cases or because they are considered as cases not involving stakes which may adversely affect the interest of the state. Therefore, the circumstances of non-filing of appeals by the state in some similar matters or the rejection of some SLPs in limine by this court in some other similar matters may by itself, in our view, cannot be held as a bar against the state in filing SLP or SLPs in other similar matters where it is considered on behalf of the state that non-filing of such SLP or SLPs and pursuing them is likely to seriously jeopardize the interest of the state or public interest.
Those grounds are less. Then you can take up the contention. We did not challenge that because stake involved was very frugal. Therefore, we did not challenge. And issue was also not that big. Therefore, we did not challenge. That is not even true. Not even a sentence is whispered to attract this decision. In your appeal memo, you have not said anything as to why that judgment was challenged, not challenged, why it was allowed to lay at rest and give benefit to rest of the people on that base. Singling out this person from the sphere of that judge. That is not permissible. You are a model employer.
Nobody has given the benefit of that.
We don't know. We have time for taking the benefit by seeking hanging of the officials who do not give it.
Well, that order has not been implemented as on today.
Whether you implement or not, an order is an order.
So no benefit is granted to anyone.
No, that makes no difference. Anything more?
Similar, this is my...
Understood. Kindly sit down. Permit your friend to argue. He may dilute your weak point also. Let us see.
Let's say I am front of your lordship. So your lordship is the law of heaven. So I will only place the facts, your lordship may decide.
You have argued well. Yes.
My lord, I had handed over that copy of that rule, OCS RA rules. My lord, put that question to him whether the rule mandates that permission need to be taken, and if so, under what circumstances. My lord, that is...
For that he fairly said that there is no such rule at all.
He says there is no such rule, but there is a clear-cut, the rule itself says under what circumstances the permission is needed. That is what I have pointed out in my written, in that date chat, but still I am taking your lordships too. And your lordship, your lordship have also observed by noting the speciality of this rule with regard to regular recruitments.
And your lordship, I will not take much of your lordship's time. I am just pointing. Your lordship kindly have that rule. I'll so two to three provisions.
Yes.
But I have extended. I have the 2 copies. My lord, only one line. My lord, may kindly see the preamble itself. In exercise of so and so, I am skipping it. Government of Orissa hereby makes the following rules to regulate recruitment to state civil services and post in plural as a measure of rehabilitation assistance. So this is a rule exclusively made for rehabilitation.
What you say is the 2013 rules are not applicable to these.
Yes, and why I say so? This is for this particular purpose.
Special rules.
Yes, this is a special rule. Now your lordship kindly, because the main writ appeal doesn't contain that particular rule, I have extended this copy to your lordship. That is my fault because I had missed it giving before the learned single judge at the initial point of time. Pay rule 15. Your lordship kindly see.
Rule 15
of these OCS RA rules.
RA rules.
Yes. That is the clinching provision. Your lordship kindly see. I am extending another copy. I am extending another copy. Your lordship.
Rules only. This is only.
Odisha Civil Service Rehabilitation Assistant Rules.
That is amended in the year 2016.
No, just
1919.
16.
Please.
You were reading 15.
Yes, ma'am. Rule 15. The marginal heading given at the
Writing effect.
Yes. The provisions of these rules shall have effect notwithstanding anything to the contrary in any other recruitment rules made under the proviso of Article 309 of the Constitution, including so and so. We are not concerned about the ex-servition rules. So it has been given specifically overriding effect over all rules.
So general rules will not apply.
Yes, that will not apply. And moreover, you will also put that question whether in the present case that permission was required. You will also kindly come to rule 8.
In certain circumstances, permission is required.
Rule 8.
In other circumstances,
but not in the present case. I can demonstrate that. You will also kindly come to rule 8. Rule 8, you will also kindly come to 1, B, C and D, these three sub provisions. On receipt of the application, the appointing authority shall send a requisition to the collector of the district in which the family ordinarily resides, calling for a report as to whether the family is in financial distress. C. On receipt of the requisition from the appointing authority under Rule 8B,
within 1 month,
the collector of the district concerned shall cause an inquiry into the matter and furnish his report to the appointing authority within 1 month from the date of receipt of the requisition. Next, the appointing authority upon receipt of the report shall consider the same and issue, and in case of favorable report, appoint the applicant in a suitable vacancy under his control, full stop. If a vacancy does not exist under his administrative control, the appointing authority may forward the application. Now you lots may kindly come to the facts of this particular case. You lots may kindly see 3 documents. 3 documents given in the writ appeal itself, available, given before the learned single judge.
The head of the department shall appoint the candidate.
Yes, my lord. Here the transport commissioner.
Or in the office's subordinate.
Yes. So here, my lord, the transport commissioner is the appointing authority. And your lords may kindly see what is the date. Your lords may kindly come to 3 pages. Page 35.
35 of
the writ appeal. Of the writ appeal, page 35. That is my application. It starts from running page 34. You will also kindly mark only date. Date of my making application is 1/8/2012, when my father died on 4/4/2012, after within 4 months. Next page, you will also kindly turn over. The collector Kotak has granted that the distress certificate.
They are found correct.
Yes, that's all right.
Inquiry is done
and the date. And the date, my lord. The date is important. The date is 8/12/2012.
8/12/2012.
So you made the application 1812?
Even before the RA rules were promulgated.
CA rules, that contractual rules. That is what I want to demonstrate before your lordships. Your lordships may kindly see. So my collector has given distress certificate in my favor. Now the Transport Commissioner, being the appointing authority, need not seek permission as has been done at page 39. Your lordships may kindly see what is the date also. On 1/3/2013.
But one thing we should say, both you are very competent lawyers. Your competence is our predicament.
But we are learning from your lordships every day.
No. We also learn like that. I also learn.
But page 39, your lordships may kindly see. My appointing authority, after getting a favorable report, instead of issuing appointment order when the rule says shall, your lordship knows what is the interpretation of shall. I need not say, seek permission of the government, which is not at all required, And your lordships may kindly see what is the date on which that contractual appointment Group C, Group D rule came. That Group C, Group D rule was made effective on 18th November 2013. So by the date, my lord, all these formalities were over. The rule was nowhere seen in the picture. But still, my lord, they took advantage of the situation to annul the adjudication which took place in between. They went on doing once the action or other to deny me. I went and challenged it before the tribunal. Tribunal the repeatedly directed for my appointment, specifically saying appoint him in any post under OCS RA rules 1990. And your lordships may one provision, your lordships may.
No, when it was, they said the tribunal was abolished and matter came to.
No. Prior to that.
Even earlier there was.
Yes, well, that was it.
But why the appointment was made in the year 2018 from 12 onwards, and between 2012 and 2018 there are several litigations between the parties. Yes. That is admitted on record.
Every time I succeeded.
Which are those then heavy costs need to be imposed?
My lord, may kindly see.
Which are those decisions?
Yes, my lord, your lords may kindly see one decision running page 50, the operative part.
Kindly tell me the number.
Yes.
OA number.
OA number 2030. Just a minute. 2030.
Clearly mentioned in my data.
2030C of 2016. It starts from running page 47 and the operative part is page 50.
2013. 2030 of
2016. Sorry, I'm sorry.
2016. First case.
Yes, that was the first case. When my lord, your lordship put another question. My lord, your lordship put that question whether the medical certificate record have insisted. My lord, here is a case.
You come to that. We have
in this case the rejection
only in this case. In the 2030C,
my lord,
of 2016.
They say they rejected my case, saying since your mother was there, even if she has been declared medically unfit, and the certificate was produced before them, they say since your mother was alive, so she should have come forward with the appointment. No, you will not extend the appointment in your favor. That was quashed by this tribunal. Saying you cannot, when that person is medically unfit, you cannot expect her to take up employment. And that is why the application of the applicant was directed to be appointed under groups Odisha Civil Service RA Rules 1990.
Once again, this OA is decided on which?
4/8/2017. There are all these pleas.
Wait.
You put off that mic. You don't need mic at all.
No.
Perhaps, arguably, you may need a silencer. OA 2030 is disposed of.
Yes.
Then another OA.
What
OA directed what it said?
Yes, my lord. After getting this order to give me.
What is that order?
Well, the order is at page 50.
That the son is entitled.
This order, my lord.
Is it?
Yes.
What is that order then?
Well, this here, my lord.
Consider the claim or give the appointment.
Give appointment. PS 50 may kindly be seen. Your lords may kindly see.
Right, we'll take note of it.
We believe you.
Respondents are directed to appoint the applicant. Petitioner was the appellant there. Respondent number 1 here is the appellant there. In any suitable post under OCS RA Rules 1990 within a period of 2 months from the date of receipt of this copy of this order. After getting this order, what they did, they again asked me to make fresh application under the amended rule.
In the meanwhile,
Just a minute. So I challenge that.
OA number?
That is OA number 3351C of 2017. 3351C of 2017.
Allowed on?
That is allowed on 8/12/2017. Directing the state to appoint in view of the other order passed in the first round of litigation. That means under the OCS RA, appoint the applicant, the respondent number 1 herein, under OCS RA rules against any post covered under OCS RA rules.
That was not challenged.
That was challenged before the Hon'Ble High Court in 2 writ petitions.
Why 2 writ petitions? Earlier one and this.
Both the judgments were challenged separately in 2 separate writ petitions. That is the
one second. Just wait. OA 2030C of 2016 was to challenge rejection of respondents' claim for compassionate appointment on the ground that the preferential claim of the mother remained since mother was alive.
Irrespective of his medical unfitness.
The tribunal OAT, the OAT allowed by the order dated 4/8/2017 with a direction to appoint respondent herein, respondent's son, herein in 2 months.
In any suitable post under OCS RA rules 1990, that is clear.
In any suitable post under the provisions of
OCS
RA rules 1990. Next one. This order was challenged in WPC
14714 of 2018.
What happened to that?
That was dismissed by a division bench of this Hon'Ble Court.
Dismissed, challenged by the state. And the same came to be dismissed on
14/8/2018.
14/8/2018. Any direction was given, time bound?
Yes, my lord.
So what they say?
My lord, they say comply with the direction to comply with the order within a period of 2 months. We only extend the said period till end of September 2018.
However, a period of 2 months was granted for implementing order of the tribunal. First. Next paragraph. OA 3351C of 2017 was filed challenging the order of the government. Commissioner.
Government.
Order of the government. What it had said?
It has said
you apply afresh?
Yes, apply afresh under the amended rule.
No.
Everything will be started afresh from the beginning.
Order. That order was dated
24/8/2017 at Ronnie page 51. That is there.
24/8/2017. 17. Whereby.
And 12/10 and consequential order dated 12/10/2017.
Respondent's son was directed to apply afresh
under the amended rules.
Appointment under 2016 amendment.
Yes.
Under 2016 amendment to
afresh.
RA rules. Since rule regime was changed. First, this was allowed on 2017, 8/12/2017 with a direction to appoint respondent to
Under OCS RA rules,
OCS RA rules,
19.
in view of the direction given in other case, 2030C of 2016.
Ignoring all other orders.
Madam?
Ignoring all other orders, you said.
No, ignoring.
Tribunal said that?
Tribunal reiterated its earlier order of appointment.
Okay.
This.
Then what do you say? The direction to
as per the order of the tribunal in
terms of earlier order.
Yes, OA number 2030.
Made in OA number 2030 of
C of
2016.
Yes,
This code of on 4/8/2017.
Yes, that order was challenged.
This was challenged in WPC.
Yes. WPC, the 14715 of 18.
That came to be rejected
on same day, 14/8/2018. So
on
this under
14/8/2018.
Yes.
Affirming OAT order.
Yes. Both the orders.
Both the petitions were disposed of with a common order.
No, the separate orders, but on the same day, by the very same bench, division bench.
With a DP.
Yes. Page 62, your
On
lordship.
the same day, the WP, which is the WP in 20306?
That is 14714. It is 14715. Consecutive number.
147.
Previous one was 14714. The subsequent one was 14715 of 2018. So they preferred consecutively two writs challenging two separate orders of the tribunal, which came to be disposed of on the very same day, that is 14/8/2018, by separate orders.
Okay. Then what happened?
Then they issued the appointment order. Then they issued the appointment order on 13/12/2018.
The appellants issued appointment order
13/12/2018.
on 13/12/2018, stipulating certain conditions.
By following the clarification issued under the Group C, Group D contractual rules.
On the basis of some clarification issued under some other set of recruitment rules.
The clarifications were dated 31st December 2014 and 6th February 2015.
Where clarifications dated
31st December 2014 and 6/2/2015.
First one. Respondent filed OA number.
The respondent filed OA number 1554 of 2019.
That came to be allowed on
30th June 2023.
WPC that has been transferred before this amendment.
No, allowed. He's saying allowed.
Yes.
Allowed by
After transfer.
After transfer.
WPC.
The said OA came to be transferred to this court, a single judge court, because of abolition of the tribunal.
Yes.
And on transfer, the application OA was renumbered as WPC.
OA, bracket OA, number 1554 of 2019. Same number has been written.
Yes, only OA was not per identity.
WPC.
WPC has been prefixed.
First, that came to be allowed by the impugned order dated
30th of June 2023.
By the learned single judge.
By the learned single.
Now, what the learned single judge said?
The learned single judge has directed that the order passed in the another case, that is
learned single judge followed another judgment made by him.
Yes. Dated
in WPC number.
A batch of cases. WPC number 2062 of 17 and four others.
You have to write down.
Yes, sorry.
This slow.
Sorry.
WPC OA number 206.
WPC OAC number 2062 of 2017.
And a group of
and three other cases, writ petitions.
Biplab Kumar Sahu versus
Yes. Page 82.
Biplab Kumar Sahu versus
State of Odisha and others.
Yes. There that 6/2/2015 has been
That
passed.
is an elaborate judgment. Yes. Which had the fact matrix of the appeal at hand. First off. Next point is this just now I give dictation. Over or you want to say something else?
No, only
So that will result in
I did not. I know your lordship's mind.
No, not
only one line.
Yes.
Can I say with your lordship's permission?
Yeah.
My lord, the so-called implementation on which my lord, the friend appearing for the appellants is insisting upon, that is dated 18/3/2023 at an anterior point of time during lease pendant of this cases filed before the tribunal. Both the judgments, one was delivered on 26/3, the other in my case was delivered on 30th June 2023. And the so-called complaints on which they claim that they were ruling bona fide, that was the order passed by them extending the benefit is dated 18/3/2023 at an anterior point of time during lease pendants.
That is in the contempt now. This order, what happened?
This order, when they say this order is the compliance of the court's the court's order dated 30th June, the Honorable Court simply deprecated, saying this cannot be treated as the compliance of my order.
May I submit one?
Yes.
May I submit one thing? At the time of delivery of the judgment before the learned single judge, the petitioner, the respondent has been irregularized. He may get notional or otherwise, but that has not been pointed out before the honorable single judge.
Why notional? That means a whole life.
Exercise.
That individual has to be in the court.
Yes.
Court is not that happy place.
So the honorable single judge has neither dealt with that repeal rule or.
And
he also did not enjoy his work at any point because he allowed him to only in the court.
But Honorable Court has recorded the admission of the State Council that my case is covered by the other adjudication made. One more submission, my lord. My lord, you also may consider. But the so-called Odisha Group B, Group C, Group D contractual rules 2013, once it is repealed in 2022, prior to implementation, the so-called implementation, what would be the effect of pro tanto repeal? I am not saying anything.
No, repeal is prospective in operation.
Prospective in operation. And your lords, my lord,
again, it's a double-edged weapon because if repeal is prospective, rules are also prospective.
Yes.
Unless otherwise said.
Yes. So, my lord, my entire case is all through my consideration was required to be made under the OCS RA rules. And all these adjudications put their respective seal of approval on the same the adjudication and the direction. And Rule 5 of Rule 7 of the state rule says, I am required to be appointed in the time scale of pay. That you also may kindly see. Rule 7 says only one line. Appointment under these rules shall be made once against any post, either in Group C or Group D, in a base level post in the said groups, and the maximum scale of pay for such posts in Group C and Group D shall not exceed so and so, as revised from time to time. So the rule mandates appointment in Group C regular post, that too with a time scale of pay, not under contractual with consolidated pay. That is what my case before the single judge and now before lordships.
When the employee died?
Employee died on 4/4/2012.
For 2012.
Yes, ma'am.
Right now. This intra-court appeal by the state and its officials seeks to call in question A learned single judge's order dated 22/3/2023 entered in respondents WPC number 3062 of 2017. Go sit down and answer.
Yes.
3062.
Yes,
or
ma'am.
20. It's not forthcoming correctly.
3062.
3062 of 2017.
Sir, 2062 of 20, that is 20. 62 of 2017.
2062.
2062, page 82.
2062 of 2017.
Yes, and 3 others mentioned there in the above.
That is Viplav Kumar Rao.
Not this. Your order, the petition came to the order, which is the impugned order.
Impugned order is dated
Impugned order.
36/2023.
WPC OAC 1554.
WPC OA 1554
Sorry.
of 2019.
Sir, that is 30th June order, but in WPC
Wait, that is
1554 of 90. Oh, bless.
The operative portion of the order reads as under. Where is the operative portion?
Paragraph 6, your lordship may find as page 80. Having heard law and counsel for the parties.
Last operative portion.
Yes, considering the materials available on record and submission made by the law and counsel appearing for the parties, this court dispose of the writ application in the light of the order passed by this honorable court on 22/3/2023 in WPC OA number such and batch.
Operative portion of the order reads as first. Obviously, this order has been rendered keeping in view the order dated 22/3/2023 made by the learned single judge, made by the said judge in Viplav Kumar Sahu versus State and others. In WPC OA number 2062 of 2017 between Viplav Kumar Sahu versus State and others, along with companion cases. First. Go to Viplav Kumar, which is page number.
That page 81, starts 81.
The operative portion.
Operative portion, lordship may find
86,
that has been quoted in the order of the impugned order.
86.
Page 80, lordship may find
It is 87.
the operative portion of the order has been quoted. Page 80, lordship may find.
No, that is also not Viplav Kumar.
Yes,
No.
page 86.
Viplav Kumar, yes. 82. It starts from 82.
It starts from 82. That is what I said. It starts from 82. The operative part starts at paragraph 6.1.
6.1.
At page 86 and continues in the next paragraph. 87.
And that para 6.1 has been quoted in the impugned order in appeal. That is at page 80.
The operative next paragraph. It is relevant to reproduce the operative portion of order in Viplav Kumar Sahu Supra, which is as under. Go to page 87, mark it yellow, only that portion.
Page
87.
87 subpara.
Subpara is there, na?
Yes.
6.1, it starts from 6.1. Placing reliance on
6.1. 6.1.
Yes.
6.1.
That any clarification issued? Yes.
Next paragraph. Learned ASC. Are you ASC or AGA?
Standing Council Transport.
Love that the Standing Council appearing for the appellant state and its officials vehemently submits that the learned single judge grossly erred in granting relief to the respondent hearing, that is the writ petitioner, in terms of decision in Biplava Kumar Sahu Supra, without adverting to the arguable merits of the case on its own. First off, in support of this, he presses into service a decision of the Apex Court in Colonel B.J. Akkara, AKKARA, versus Government of India, 2006. Eleven SCC 709. More particularly, paragraphs 24, 25, and 26 thereof. Yes. Secondly, he submits that the conditions stipulated in the order of compassionate appointment, what is that date?
18/12/2013.
18/12/2013. No.
13/12/2013.
13/12/2013. Basically.
13/12/2018.
13/12/2018.
Conditions were stipulated when? Conditions 2 and 5, you said, na? In that which order?
My lord, in that 13/12/2018.
In the
Appointment letter.
but compassionate appointment letter dated
But the appointment doesn't say that it is contractual. You also see
13/12.
13/12/2018.
18.
Yes.
18. You have written? So and so. The conditions were perfectly stipulated in consonance with the contractual appointment rules 2013 that came to be promulgated on 18/11/2013, and therefore interference of the learned single judge was uncalled for. First one. Lastly, he submits the CA rules 2013 are very expensive and they are applicable to any appointment, including compassionate appointment, and therefore making the same contractual in terms of the said rules would not have been faltered.
That rule 9, 1 and 2. I am.
He draws attention of the court to rule 9. Rule 9.
9, 1 and 2 of CA rules. That is, Lordship may find page 40.
Sub rules, you can say. Sub rules, rule 9 of CA rules. CA rules.
That is RA rules.
RA rules.
RA rules.
RA rules.
RA rules. First. Next point. Learned counsel appearing for the respondent in his usual vehemence resists the appeal, making submission in justification of the impugned order and the reasoning adopted by the learned single judge while constructing the said order. First off, in pith and substance, he contends that his client was harassed at the hands of the appellants inasmuch as he was driven to launch too many legal battles in which he emerged victorious, and that now he is being vexed at the hands of the appellants in the appeal at our hands now. First off, he submits that the rules relating to compassionate appointment in any civilized jurisdiction are treated as special rules, and therefore general rules of recruitment such as the 2000 rules, 2013 rules, you're right, cannot have overriding effect at all. First off, in this connection, he presses into service, which is that overriding effect. Rule 15. Rule 15 of CA rule, RA rule 1990. Yes. First off, he also notifies to the court the flagrant violation of several orders passed by the OAT and by the division bench, which affirmed those orders. First off, so contending, he seeks dismissal of the appeal. Next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter for the following reasons. First one, as to delay, grouped in filing the appeal, heading, as to delay, heading. Below that, this intra-court appeal has been filed by the state and its officials, as mentioned above, after brooking a long delay of 849 days.
79, how in it will be 879 if you
whatever office note has come.
But office note has come.
Yes. Otherwise, it will be less than that.
No,
more than that.
It will be more by another 30 days.
Yes. An application supported by affidavit seeking condonation of said delay has been filed. First, the application mentions about various litigations between the parties and also promulgation of CA Rules 2013 and their subsequent repeal with effect from 17/10/2022. First one. It is also argued that in matters like this, delay would normally be condoned in as much as rejection of the request for condonation would result into enormous prejudice to the interest of state, which has acted with no ill motive. First one. this contention is a submission is resisted by the other side on several grounds. First one, the law of limitation is the law of peace and repose, says Salmond in his jurisprudence, 12th edition, Pejara. First one, the sages of law say that law will not come to the aid of sleepy and tardy. First one, law applies to the crown and commoner with equal measure, subject to all just exceptions, into which argued case of the appellants does not fit. First one, delay is too long to be condoned. First one, long delay would make right of the private litigant concrete by lapse of time. First one, justice of the case would be met more by rejecting the request for condonation than by favoring. It is relevant to mention that the Apex Court in Postmaster General versus Living Media India Limited, 2012, 3 SEC 563, at the paragraph 172, has observed as under. Here, na? Just therefore, the subject application is liable to be turned down, and accordingly it is. First. Next paragraph. Contention as to CA Rules 2003 being applicable to 2013 being applicable to compassionate appointments. Underline. Learned standing counsel very fervently argued that the claim of the respondent, son of the deceased employee who died on 4/4/2012, although was processed under RA Rules 1990, during the period of processing, the CA Rules 2013 came into force with effect from 18/11/2013 to be precise, and therefore the appointment order was issued, letter was issued by stipulating certain conditions, and the same cannot be controverted. Assay is SAILED. Just to keep going. Per contra, learned private counsel appearing for the private respondent draws attention of the court to Rule 15 of CA Rules 1990, RA Rule 1990, which reads as an Rule 15, you have to allow this. Right? Such a overriding rule is conspicuously absent in CA Rules 2013. First of all, even otherwise, CA rules do not make a lip reference to the RA rules of 1990. First of all, if the rulemaker intended that the 2013 rules should govern rehabilitatory appointments as well, it would have in so many words or explicitly or impliedly would have made such a provision in the 2013 rules themselves. First off, even otherwise, the rules relating to compassionate appointment in all civilized jurisdictions are treated as a special law that would override general law on the principle of specialibus generalibus, you keep it that way, ask our maxim, Broome's legal maxim. Therefore, the contention of learned standing counsel is liable to be rejected, and accordingly it is. Next point. When was that compliance order was passed?
Compliance
Compliance order was passed
18.
That is 18/3/2023.
18/3/2023. Lordship may find at
2023.
Yes.
That is at page 90.
Next point. Heading. As to compliance order dated
18/3/2023.
First one. Permission of learned standing counsel that the compliance order having been passed on 18/3/2023, the respondent could not have had any cause of action in respect of his compassionate appointment is bit difficult to countenance. First off, as already mentioned above, the breadwinner of the family died on 4/4/2012, and that the respondent, being the son, has been hovering in the court and tribunal in court and tribunal through with a plethora of litigations. First off, even the conditions of the compliance order make it obvious that all the benefits which the respondent was legally entitled to, had he been appointed on compassionate appointment in due course under the RA Rules 1990, was effective. Whatever it was.
Appointed under the
was being made. In as much as the said compliance order speaks of notional benefits. First, the compassionate appointments are not meant for notional benefits. First off, they are meant for concrete benefits that should reach the hands of bereaved family. First off, otherwise, the very intent and content of the subject rules would lose their salt and meaning. First, it hardly needs to be stated that even the apex court in a catenary of decisions has deprecated harassing members of the bereaved family who stake their claim for compassionate appointments under the rehabilitatory schemes like 1990 rules. First off, it is said that the state is the first enemy of the citizen. First off, the conduct of the appellants prove this, to say the least. First off, the breadwinner having died in April 2012, years have lapsed by the time the compassionate appointment letter reaches the hands of the respondent, that too with the onerous stipulations that are obviously unsustainable. Next point. As to maintainability of challenge to the appeal. Learned counsel appealing for the respondent fervently opposed the appeal on the ground of maintainability, contending that the impugned order has been structured by the learned single judge in the writ petition, in his writ petition, in terms of his order dated, in terms of his judgment dated, which is that 1820, that judgment, earlier judgment, which he followed. That is in Viplava Supra 22/3/23. Supra, there being no challenge to the lead judgment at all. First off, per contra, learned standing counsel placing reliance on a decision of the apex court in Colonel B.J. Akkara contends that appeal of the kind is maintainable. First off, let us examine what has been observed in Akkara, wherein paragraphs 24, 25, and 26 read as an. First off, the apex court, although negatived the contention as to maintainability of appeal of challenge of the kind, comma, it specified the circumstances which would come to the aid of challenger. First off, no way in the body of appeal a whisper is made about the circumstances in which the challenge by way of exception is maintainable. First off, Therefore, we agree with the contention of learned counsel appearing for the private respondent that this appeal itself is not maintainable. When the maintainability is treated in the light of the decision in Akara and the other decision referred to in Akara. First up. As to next point. Other miscellaneous contentions. The other related contentions as to 2016 amendment rules to CA rules 2013 and their repeal with effect from 17/10/2022 would pale into insignificance, being thoroughly misconceived. First one. Then main paragraph. Having heard I said now, then that paragraph. This is a case of checkered history that would exhibit a kind of callousness and a litigious mind attributable to state and its official. We said officials, no? Official, only one. First one. Which I gave dictation earlier. Put it here. Are it? Any standard book on normative constitution like ours would say that the state and its officials have to conduct themselves as model employers, as observed by the apex court in so and so. In that is Hajarika, Bhupen Hajarika, right? Bhupen Hajarika was the state of Assam. And as a model litigant, as said by the apex court in the case of so and so, so and so. First off, state is mighty and citizen is not. First off, more particularly, persons seeking compassionate appointment belong to the lower echelons of the society. First off, death in any family will bring a train of problems, and in a family of a lower strata, the society would bring innumerable difficulties. First off, that is the reason why the civilized jurisdictions make policies for rehabilitatory appointments. First off, the claim for such appointment has to be treated on a war footing so that the purpose of the policy is achieved. First off. However, that has not happened in this case. The conduct of the appellants in driving the poor respondent to a plethora of litigations is nothing but an abuse of the process of the court, if not of the law and of the system. First one, we are told at the bar that the respondent is fighting another legal battle in contempt content number so and so,
Yes.
so and so
2097.
pending on the file of learned single judge, which we had for the short interdicted, for a short time interdicted because of pendency of this appeal. First one, it is very difficult to compensate the agony which the poor employee like the respondent is militantly put to. First one, however, it is said that monetary compensation is the panacea to all maladies. First one, we are of the considered view that this appeal should be dismissed with the exemplary cost of rupees 1 lakh payable by the respondents together, appellants together, to the respondent in a time-bound way, coupled with a default clause. First, in the above circumstances, this appeal being thoroughly devoid of merits is liable to be dismissed, and accordingly it is, with a cost of rupees 1 lakh, which shall be remitted by the appellants together to respondent within a period of 6 weeks, failing which they shall be liable to pay rupees 200 per day of delay for the first month and rupees 500 for the days next following.
But one more thing. On dismissing this appeal, now we comply the order of the.
We do not.
You
say it to
I pray sometime. Oh Lordship, not that much, oh Lordship.
No, we cannot, brother. See, otherwise people will lose faith in the government. There is a death in April 2012. We are in 2026. 2026. What has happened to that lady and to this gentleman?
He was appointed in the year 2018.
All right. 18 also. 12 to 18, 6 years. 6 years, how they should serve. Government to pay this. It will, because Supreme Court may release it, or it may enhance also. But we want you to test this order.
Next item,
Test this order.
next item, which chapter? 38 item.
Next item, my lord. Next item, counter.